My lord, may I be permitted to mention your lordship's order dated 17/4/2023. There is a request from all sides, my lord. Your lordship has made that committee to sit with the government 5. Can it be made 6? Because, my lord, several staffs of this Honorable High Court, they also want one representation, and 6, it would be fit everyone. If possible to be mentioned tomorrow, just the 5 may be made as 6.
Where is you have to ask the Advocate General.
I have talked with the Advocate General. Advocate General in the morning today said that I cannot do anything. If the Chief Justice, my lord, makes the committee from 5 to 6, he has no objection.
Yes, sir.
Orally, he has intimated me.
We can show it as days list to be mentioned.
Milord, in great predicament, Milord, may mention, Milord.
This matter has been listed under the caption to be mentioned. It is submitted by the learned counsel for the learned counsel representing the petition, representing the fourth respondent, your federation, that this court has directed.
Page 4, my lord, of the order, so that 5 of his nominee can participate in the meeting on that.
That in page 4 of the order, in the first paragraph, direction has been issued to the state government to fix a date for the meeting within 10 days from the date, and intimate the convener of the fourth respondent federation so that 5 of its nominees can participate in the meeting. It is submitted that the number of nominees of the fourth respondent federation may be made to 6 instead of 5. We have heard the learned. It is submitted that the learned Advocate General also does not have any serious objection in this regard. Accordingly, the figure 5 shall stand modified as 6, and this order shall form part of the order dated 17/4/2020.
Grateful, man.
Yes.
Well, I have been orally intimated by the advocate.
Milord, great predicament, Milord, mentioning item number 75, Milord, of today's list. Milord, the predicament is, Milord, tomorrow the contempt application is, Milord, to be listed.
Let us see, because
Milord,
I went for a
if it is
program.
not taken up, Milord, may I have the leave to, Milord, mention at the time of rising, Milord? For
Let us see who appears for the respondent.
Milord, I'll serve on the read, Milord.
Item 75.
75, Milord.
You need to get the advocate. Let us see.
Lordship, I'll, in the meantime, I'll give a notice.
1 o'clock. 1 o'clock.
Lordship.
With regard to item number 678 of month's list, I for the private respondent, the appeal has been abated, my lord. Let it be to be mentioned.
You give the slip.
Lordship, may I seek leave to file appeal without certified copy?
What is the urgency?
Lordship, it is Group 4 matter, Lordship, and there is no state. Writ has been dismissed. And Group 4, Lordship, it is by next Friday, whenever it comes. If I get certified copy, I will file that, Lordship.
Yes,
Your Lordship, may I be permitted to mention, Lordship, in this matter, the applicant has applied for new electric connection before the CSC authority.
You want upgradation?
Lordship, the matter is not in the list, and CSC authority is not giving the connection, and I am without electricity.
You mentioned next week. Already, we can't finish this list also.
Your Lordship, may I be permitted to mention this matter is of extreme urgency, Your Lordship. The basic contention is that during the Eid ki Namaz in Red Road congregation on the particular day of Eid ul Fitr, the Honorable Chief Minister uses various words or various terms which are against the opposition political party in a religious platform. Previously, a writ application, a public interest petition was filed, but that was dismissed because the prayer in that public interest petition was that she cannot enter that congregation. But here we actually pray for.
No, all these writ petitions on apprehension we can't.
Sorry, there is no breach of peace, Your Lordship. That is our only content.
Can't apprehend breach of peace. Sorry.
So this is an order of 5th of your good self. So I just want to recall this order. There are certain fundamental rights as a hospital and as a professional.
You file an application. Okay. Recalling can't be done by oral mention. Please call the list.
Lordship, may I be permitted to mention, Lordship, one writ application for treatment of the patient suffering from muscular dystrophy was filed, which is similar to a public interest litigation, which is pending before this court.
Next, call the list, please.
Appellate side daily list, item number 1.
Order for the petition.
What is the correction?
Well, in the second paragraph, third line, it has been recorded as 9 nurses.
It will be, my lord, 4 doctor and 5 nurses.
This matter has been listed under the caption for correction.
It is written
It is
9
pointed
nurses.
out by the learned
There are 4 doctors,
advocate
5
appearing for
nurses.
the petitioner that in paragraph 2 of the order, it should be mentioned as 4 doctors
4 doctors and 5 nurses.
and 5 nurses
Lordship.
instead of 9 nurses. The said correction be carried out and this order shall form part of the order dated 17/4/2020.
Take it in, sir.
Next,
Item number 2,
yes, what is item 2?
Well, I am for the petition appellant.
You mentioned yesterday.
Yes.
What is this?
The writ petition was dismissed. My lord, we have paid for appeal. Stay has been granted. Stay order to appeal. My lord, his returnable date was 12. My lord, under compelling circumstances, I have taken the jurisdiction of this honorable court because there is totally disorder in the bank debt recovery tribunal. Because my lord, this is the case of outside Calcutta. The entire matter to be based out of my lord on bench number 3, but 3 is totally absent. Bench number 1 has given the direction to deal with the matter of bench number 3. The presiding officer bench number 1 has the brain surgery. He used to get 2-3 matters in a day and thereafter got up from the chair. On 18th, my learned junior has mentioned the matter with put up petition to take up the matter, but my lord, it was not granted. Prior to that, my lord, on the basis of this, we are coming to this. My lord, what happened to lordships? My lord, I am going.
Now, there are 3 benches.
There are 3 benches. Only one single bench, first bench was given the direction, but charge of the bench number 3.
Now, first bench is not regularly sitting.
No, he's having the brain surgery.
Now, second bench is vacant.
Second bench is vacant. Vacant.
So what about third bench is also vacant?
Vacant. Well, may I submit to lordships? Well, I am not traveling to lordships regarding the merits of the case, but it is, I am totally slight touch of this. Well, they have only one way taken the arbitration. They have conducted the expertise arbitration award. They have not going to execution. They have issued notice 13-2. 13 port have been issued. Thereafter, I have preferred my essay in 2021 as per the section 17, Act 54. That 21 matter has been heard. In the taking the advantage of this, the absence of the bench, the financial company issued notice to the district magistrate under section 14 of Act 54. On the basis of that, they have taken the police help and they have totally procured my entire house with all the belongings. All the belongings.
No, your stay application in the
Yes, pending. Even thereafter, in the meantime, may I submit to lordship? I am not finished. Thereafter, what happened? They have given me 46 lakhs with the mortgage of my household property. Thereafter, EMI, I have paid 15 lakhs. 15 lakhs off and on. During the COVID situation, my lord, due to that, my lord, my business has collapsed. I said to the bank, they have some arrangement or settlement of that. They are stick the point. And also, my lord, they can see on 24th.
No, we will direct the bench number 1 to take up your stay petition in that.
I have mentioned on 18. Today is 20th. 18th, I have mentioned.
No, we will direct that stay petition to be taken up.
Taken up. In the meantime, states will continue.
Obviously, but now, did you see yesterday's judgment of the Supreme Court? This is M.R. Shah and this is M.R.
Yes, I know.
It is not maintainable. And more particularly, it is a NBFC. The respondent, it's a finance. Cholamandalam.
Now, also, what is the problem is this, my lord? They are coming from the outside the states, and my lord, they have the office, registered office in that state. So we have to pay for any application to them, I have to go there.
That your client should have thought before borrowing. Because they gave loan without.
May I suggest, lordship, my lord? My lord, kindly direct my lord the bench number 1 to dispose my stay application. In the meantime, my lord, stay till the disposal.
No, what is the essay number?
Essay number?
65.
Huh?
265.
265.
Of which year?
2021.
Of 21.
We have filed the
And what is the stay application number?
Stay application?
In essay.
In essay. But there are so many applications I have filed. Last in the last 583. 583.
583 and 583.
583
of
2020.
2020, 583, 2023, IA, as well as, my lord, IA
566.
566, 6, 2023,
556 of 23.
23.
What is the prayer sought for? That application is here.
Yes.
NF here.
My lord, what happened to lordships, my lord? May I have lord?
Page.
It's not annexed. Not annexed.
Page not your lordship.
The last application is not there. The last application is not there.
180. My lord, which page, my lord?
Stay petition. Year. Last stay petition.
My lord, kindly come to, my lord, page, my lord, 177.
That's a P3.
177, lordship. And it was filed on 22nd March, 2nd March, my lord, 2023. Only, my lord, even lordship, my lord, kindly have a look, my lord, on page number 177.
177.
177 of the main stay petition.
Yes.
My lord, kindly come to, my lord, the operative portion, the prayers, my lord, that is 181. Prayer C.
This is IA 566.
Yes.
Injunction from
Yes.
giving effect to the e-auction notice.
The petition has left no option, my lord. Run from pillar to post.
We'll direct you are for the bank. I mean,
No, I am appearing for the bank.
we will direct the DRT 1.
But I have a duty only to indicate, Millard, the dishonest practice, Millard, that has been perpetrated, Millard, by the petitioner before this honorable court. Rest, Millard, I will leave, Millard, to your lordships. Millard, the entire petition, the writ petition, the appeal, Millard, based on absolute falsehood, and Millard, there are false statements, Millard, desperately made on oath. Millard, the writ petition, Millard, why, Millard, the petition was dismissed, I just indicate. Millard proceeded on a, Millard, false basis that, Millard, the DRT was never functioning, which is why, Millard, they never had an opportunity, Millard, to raise their grievances before the learned DRT. Millard, this was second round of litigation. In the first round of litigation, Millard, they Millard got an order on 2nd of August 2022. Millard 85 lakh and odd, Millard is 85 lakh and odd, Millard is lying payable. 2nd August 2022, Millard, in the first round of litigation, an order was passed by this honorable court by the honorable single judge, giving them, Millard, a breathing time, Millard, till 1 week from the date DRT resumes functioning, Millard, to place their case and Millard get an order. Millard, after that, Millard, DRT started functioning from 1st of September 2022. And Millard, it continued functioning till Millard 28th of February 2023. Nothing was done before DRT to place their application.
Now, how are the matters listed before DRT?
It's only, Millard, by of a put up application. It's not done, Millard, by mentioning. We have the list of even yesterday where, Millard, we can show how many matters, Millard, where, Millard, upgraded
But
and
they
taken up.
didn't take any
Not
step.
to our knowledge. Millard, let them show, Millard, a put up application.
Yes,
No?
I am saying.
Not to our knowledge. We were not served.
Because, my lord, only condition is this,
And
my
Millard,
lord, I am, Sue is
may I-
pinching to me.
May I?
Sue is pinching to me, my lord. I am pinched by Sue. My lord, whatever happened, my lord, I have mentioned the matter should not be
No,
taken
May I
singly.
make my service?
You will definitely pinch if
Should
you
pinch.
commit default.
Yes.
But, my lord, may I submit a lordship when the date has been fixed?
Tomorrow you have got a
When the
duty
date,
to
my lord,
repay.
kindly allow me, my lord.
Supreme Court says writ is not maintainable.
But kindly come to my lord, kindly
If my
come to my lord.
learned allows me, my lord, to make my submissions through.
Kindly
the
kindly
thing
come to my
is,
lord, Act 51.
Division bench, when it
Kindly
entertained
come to
the
my lord, Act 51.
appeal, thought fit to grant an interim order.
Because,
They-
my lord, the honorable division
That's it.
bench, my lord,
Lordship, my lord, kindly, matter with it.
Wait, sir, wait.
my lord, wanted us to show, my lord, the list of the learned tribunal to demonstrate that, my lord, the learned tribunal is functioning and taking up.
Within a week, we will direct them to take up the IA 583 and 566 alone. For a week, we will grant them
But, my lord,
protection.
this pargioed, my lord, statements, my lord, this can be, my lord, taken note of.
This intra-court appeal is directed against the order dated 23rd February 2022 and WPA 4264 of 2023. The appellant who had borrowed a loan from the appellants from the third respondent finance company came before the writ court with a prayer that the debt recovery tribunal does not have regular sitting, more particularly DRT number 3, and interim protection has to be granted to the appellant as the third respondent has taken possession of the property which was mortgaged and e-auction notice has been issued. The learned writ court dismissed the writ petition by the impugned order. When the appeal was entertained by order dated 16/3/2023, the division bench restrained the respondent finance company from confirming the auction sale already held till 12th April 2023. The learned advocate appearing for the appellant had mentioned this matter before this court on 19/4/2023, submitting that the order of stay had expired on 12th April 2023 and the third respondent will proceed to confirm the auction sale. The learned advocate appearing for the third respondent would submit that as on date, DRT number 1 is taking up all applications which have been assigned to DRT number 3, and all that the appellant should have done is to file a put-up petition before the tribunal and the matter would have been taken up. It is submitted that DRT 3 was functional from 2nd of August 1st of September 2022 to 2nd of February 2023.
Through, my lord, charge tribunal, tribunals in charge of, my lord, that particular tribunal. There were tribunals in charge.
Was functional
That is only black and ink.
since the cases assigned to DRT 3 were taken up by DRT 2 and the appellant took no steps to bring up the matter before the tribunal. With these facts, the appeal has been filed. No, sorry. Strike out. Thus, we need to consider as to what relief the appellant would be entitled to. At the outset, we need to point out a writ petition filed by a writ petition at the instance of a borrower from a private finance company is not maintainable. We are guided by the recent decision of the Honorable Supreme Court in South Indian Bank Limited and others versus Naveen Matthew Philip and another civil appeal number SLP civil number 22021-22022 of 2022 dated 17th April 2023. The facts in the said decision, the appellant, the bank was a private bank as the private bank, and the question was whether a writ petition could have been entertained by the High Court. The Honorable Supreme Court held that a writ of mandamus is a prerogative writ, and in the absence of any legal right, the court cannot exercise the said power, and more circumspection is required in a financial transaction, particularly when one of the parties would not come within the purview of Article 12 of the Constitution of India. Further, it was held that when a statute prescribes a particular mode, an attempt to circumvent shall not be encouraged by writ court, and a litigant cannot avoid the non-compliance of approaching the tribunal, which requires the prescription of fees, and use the constitutional remedy as an alternative. In this regard, reference was made to the decision of the Honorable Supreme Court in Radhakrishnan Industries versus State of HP 2021 6 SEC 771. Further, the Honorable Supreme Court also reiterated the position of law regarding the interference of the High Courts in matters pertaining to SARFAESI Act and referred to several decisions in this regard, and the latest being in the case of Vaira Madugu Obi Reddy. It is there in page 50 versus B Srinivasulu 2023 2 SEC 168. Further, the Honorable Supreme Court pointed out that the power conferred under Article 226 of the Constitution of India are rather wide, but are required to be exercised only in extraordinary circumstances in matters pertaining to proceedings and adjudicatory scheme, a statute, more so in commercial matters involving a lender and a borrower, when the legislature has provided for a specific mechanism for appropriate redressal. Bearing the above legal principle in mind, if you examine the facts of the case, the appellant had already approached the tribunal and filed an application in essay number 265 of 2021, challenging the measures initiated by the third respondent finance company under the provisions of the SARFAESI Act. The grievance of the appellant is that the interlocutory applications filed by the appellant for stay of the e-auction and for grant of an order of injunction against the third respondent to give effect to the e-auction notice dated 24/2/2023 is pending, and the application has not been taken up for consideration. We are informed by the learned advocate appearing for the third respondent that if prayer was made before DRT1, the applications would have been listed, but the appellant had not taken diligent steps in this regard. Considering the fact that DRT3 is vacant as on date, and those matter, and DRT2 is also
How 2 is also vacant.
and 2 is also vacant, and the matters are being dealt with by DRT1, we are of the view that though a writ petition could not have been, writ petition is not maintainable, especially when the appellant has already invoked the remedy available under the SARFAESI Act, considering the fact that the stay application is still pending, not stay application, the application for interim relief is still pending before the DRT. We are inclined to issue a direction in this regard. Accordingly, the appeal stands disposed of by requesting DRT1 to take up for consideration IA number 583 of 2023 and 566 of 2023 in essay number 265 of 2021 at an early date, preferably before before 15th May 2023. Till then, the interim order which was granted by the division bench dated 16/3/2023 shall continue.
May the time be abridged a little.
Pardon?
May the time be abridged a little, Millard. Instead of 15th May, may it be till the first week of May.
The tribunal is dealing with
Millard, it's dealing with 2 tribunals, 1 and 3. Nobody is in charge of 2. 2 learned presiding officer and Shiliguri.
12th May.
Grateful. And my lord, two more things. My lord, there is a direction upon us, my lord, to my lord, submit a report showing that my lord, there is my lord, a tribunal in charge of the 83. My lord, may I my lord, just formally my lord, hand up the reports.
According to me, my lord,
And my lord,
that is totally infractuous because my lord,
sir, there is a direction upon us.
March of my lord, condition of this my lord.
And my lord, one more thing, my lord, I must apprise. I owe and duty, my lord, to your lordships. My lord, the property has been sold. My lord, that was disclosed on the last occasion also.
The same interim order.
I'm
Great.
grateful, my lord.
Great.
I'm
Item
deeply
number
obliged.
3,
I'm deeply obliged.
item number 3.
Yes.
My lord, this is the medical
Abhinam.
matter. Well, my lord, the lordship had directed the West Bengal Medical Service to produce the file.
Original file. Yes.
As per pursuant to lordship's directions, the entire records dealing with this case.
Now, have you flagged the relevant portions? Is your officer here? Your officer is not. You should have asked somebody to be present. Because page 96, annexure P8, that was the communication sent to the writ petitioner, correct? Stating that
That was an unreasoned order, final order that was passed.
this is the only order was passed. But last occasion you had submitted that. No, detailed order was there. And this is only what was communicated by the registrar. So you please flag that portion and show how we will go on. You should have asked one of your officers from the medical council to be present here.
No, they send me the entire file. It is chronologically it is arranged from starting from
But
the
my lord, what
receipt
is the
of complaint.
foundational basis for this order? Reason
No,
behind
no,
this
you
order.
please show which is the recent order which was passed.
Put that, not your losses of raise that point. I have to answer it. Whether the first of the question I am raising, whether this council under the scheme, of the act, whether we have to give any reason or not. In view of the decision of Constitution Bench decision, until and unless the statute prescribe or obligates me to give a reason, I need not give any reason. This is a special subject of the dealing with the doctors by the doctors, the parent body of the doctors. And there is a provision of appeal. There is a provision of even after the promulgation of the 219 Central Act, there is a two provisions of two appeals, first appeal and second appeal. Total scheme is there for appeal.
No, that is correct, sir. When the statute does not prescribe, reason should be given. That is Supreme Court or decisions are there. But still, if he has to file an appeal, should he not know what are the grounds on which he has been held guilty? How will he prefer?
No, we are not-
This says, after considering the charges as framed by office notice number so and so dated, as was communicated to you for hearing of the charges, found you guilty of infamous conduct in professional respect. That is the only thing.
Yes.
Then how, if he has to file an appeal, what are the grounds he will raise?
Exactly.
You do one thing, whatever is the minutes of the meeting, you communicate that. That he will file an appeal or he will challenge it.
But that, if he
But
asks
this
for
order
the
has to
public-
go, my lord.
No,
I am
we
under
will direct.
suspension.
I have already.
I am under suspension for last 2 months for, I don't know why.
No, you file an appeal, sir. Why do you want to bypass it? You will have a better case. You go.
My lord,
This is
what-
matter against
he has
interim
produced the
order.
file.
We have
Minutes of the meeting are there on 16th. This letter was dated 17th. On 16th, the hearing was made before the WBMC and the minutes have been recorded there. Let me.
Let us see that.
Minutes.
Show that minutes alone.
otherwise not, I have annexed it to my affidavit of opposition. I have made ready. Where this is against an interim order. There is no
Because
interim
the-
order is given.
my
against
prob-
that.
Yes,
that
ma'am.
affidavit
Yes,
of
Let us see the minutes.
Lordship kindly appreciate
interim
my
order has not
predicament.
been issued.
One second, my lord. I have been suspended for a period of 6 months. Now, my lord, opposition has been filed. I'll be filing the reply. It will be taken up as a hearing matter before the learned writ court. And my lord, in this process, if the 6 months is lost, what do I gain? And if I win ultimately, then 6 months is wiped off my life forever. No amount of monetary compensation will be able to compensate that. So is it not, my lord, a total failure of justice? And in the interest of justice, that a stay order should be passed, at least till the final
Obviously, he
hearing
has
is
committed something.
taken up by the writ
Wrong
court.
something.
That is
Obviously, he has committed wrong something. For which
obviously
he is suffering.
that is a submission
Yes,
that
it
is
is
being
the,
made.
it is the fact. And
At least
provision is
till
there,
the,
my lord. Well, appeal,
kindly let me
provision of
submit, I have not finished.
provision is there, my lord, for appeal.
At least till the
Appeal
hearing is
How will
completed
he
before
file
the
an
learned
appeal
writ court.
if he doesn't
It
know
should
on
be
what?
there.
Wait.
True.
I bow down, my lord.
How will he file an appeal if he doesn't know on what grounds he was suspended? So they made a charge sheet.
The charge sheet is dated 3rd March 21. That is at page 84 of my stay petition.
What is the date of the charge?
3rd March 2021.
Page number?
It's a letter, my lord, page 84. The initial complaint of the patient's wife was that she lost the insurance money because it was mentioned diabetic, and that was expanded later. That was the complaint. Kindly see, that is at page 77. 79. Initial complaint was that she didn't get the Mediclaim amount.
What was your response to page 84?
The response to 84 was that, my lord, first charge, you failed to evaluate the diabetic status of
petition. I have annexed in my office.
the documents are here. Kindly allow me to submit. Please
No,
don't
no. This is a charge.
Yes.
That
First
we,
charge is you failed to evaluate the
no,
diabetic.
we have read the report, sir. We have
Yes.
read the PE committee's recommendation. After you received this charge, did you not file your reply or objection?
I appeared twice over there.
No, no. In writing, you have not.
No. I appeared twice over there. There I was given questionnaires. I wrote replies to the questionnaires before the PE committee. Those are annexed. And the records are here, my lord. Kindly see, see the charges are wrong.
Reply has been given, my.
The first line, kindly see, you failed to evaluate the diabetic status of Hriday Kumar De during his treatment at Diplomat Nursing Home.
Right.
Kindly comes to page 106. The blood test is there, 106 and 107.
It is a read petition.
In the documents that I have annexed, all these charges have been replied to.
March 2020. June 2021.
Actually, the minutes of the committee has to be communicated to, because that is where it is 8 pages. They have recorded minutes.
Entire proceedings is elaborated.
Recorded. He has deposed.
It was given entire opportunity as provided in
No,
the
no.
notes.
He doesn't know the findings of the committee. The committee has now directed charge to be framed of professional misconduct. Based on that, the charge alone was communicated. What was the basis of the charge? That he needs to know. Because nephrologist has deposed, and in fact, in his first deposition, the nephrologist has said, Dr. Rabindranath Ghosh, but your client didn't defend the matter properly.
My lord, I don't know. He went there. He submitted his written
No, he
answers.
should have given his objection. He should have requested for copies of the minutes, then given his objection, saying the only issue is nephrologist pointed out that the patient was a diabetic.
Yes, yes.
And the allegation in the minutes, which has been recorded by the PE committee, is that during the stay, the patient's stay in the nursing home,
Yes.
blood sugar was never checked, recorded. No medication for diabetes. HbA1c was advised by the nephrologist, but that was not done. Still, the patient was stamped as diabetic, resulting in rejection of the insurance claim by the insurance.
Right. Kindly come to page 106 of my stay petition.
We will direct them to give the copy of the minutes.
Kindly see, this is the blood report referred by Dr. A.D. Basu.
You should
The
have
appellate.
you should have sought for the copies of the minutes.
My
of
lord,
the-
he is a medical profession, my lord.
No, you need to communicate. Sir. You need to communicate. Wait, one second.
I have already annexed in my affidavit of opposition because
Affidavit of opposition is not required now. If you have it, you can file it. We will direct the medical council to communicate the minutes of the PE committee within 2 days. He will file an appeal. See, the
Sir, I will supply it by today.
today. No, its suspension is for 6 months. By the time he files an appeal, the period will be over. The appeal will become infructuous.
That is my
So what we will do is, which is the appellate authority?
the state government.
State government. Under section 26.
26.
Whether there is any power of stay can be, whether the state government can grant an order of stay under the provision.
Nothing is there. The only line is there that they will file an appeal before the state government. There is no power given to grant stay.
So 3 months time is there to file an appeal. So the order of suspension, let it remain stayed. We will direct him, you supply the minutes, he will file an appeal to the government. Government will take up the appeal within 4 weeks. Until then, let it be remain stayed. Because this-
Kindly consider one.
no, 1.5
applied.
years back, when the PE committee inquired the matter, the death of the patient occurred 1.5 years before proceedings were initiated.
Yes.
It is recorded. It's recorded by the committee that
Kindly consider the rules we have to follow by the council. In
It is on the
every case,
technicality
when I
that-
receive the
no,
complaint,
we are not going to the merits of the matter at all.
kindly consider. After the taking decision, we have already registered his name and it was published in the Gazette of Notification. Now your lordships are giving the stay. The stay, giving a stay that means that you are passing an interim order and
To restore his registration.
yes.
Otherwise, the appeal will become infructuous. Your contention itself is you need not give any reasons and there is an appellate remedy. So if otherwise, what happens is the entire proceedings becomes a fait accompli.
Exactly.
And this order has taken effect from 17th of February 2023.
Already 2 months I am under suspension.
But his name was already registered.
Another,
He cannot-
we will direct the government to take it, finish
Expeditious.
up the appeal petition within 4 weeks. Until then, let it remain state his restoration of his registration and his right to practice will be subject to the result of the appeal.
No, but in the meantime, yes, that will be subject to the result of the appeal. But in the meantime, he would be allowed to practice.
তুমি চুয়ার তো ডান ফিঞ্জে সাবমিট করছো না আমরা প্রভিশনটা কোনো মানে
Documents have
Your
disclosed, my lord,
lordship will consider-
explicitly show that the charges are wrong. Kindly, I beseech your lordship, kindly has a look at page 106 and 107. The allegation is that I failed to evaluate the diabetic status. The blood reports are here. I've annexed them.
But that blood report which you,
Yes, page 106, kindly see.
it is not there in this file.
there is a
How can it?
note in there, there is a tampering. in the records. There is a note in the.
There is also a
There's a
note that the
tampering.
patient party has taken away all the
Tampering.
documents.
That was a note in the
These
pre-committee
documents,
report.
these
The
documents,
records of the nursing home,
Yes, record of the nursing.
medical reports were not their blood
But
report.
subsequently, it can be done.
That is the
But that's-
specific
yes,
finding of the committee.
considered by the
False
council.
report.
That's why.
my lord,
That is
there
the
is a note
specific
put
finding of the committee.
committee
Famous
report,
conduct.
allegation
6
is
and
that
7
the
false
patient
report has been
party has
submitted.
taken away the documents. The patient party has taken away the documents.
Nursing authority appeared, produced the documents. We have not prepared the documents.
এগুলো ইয়ে থেকে আমরা পেয়েছি।
This happened 1.5 years before that.
Diplomat.
না, না।
Any claim for compensation has been filed?
Yes.
Yes, now they have filed a claim before the state consumer forum.
Pending, my lord. I have made a complaint, my lord, for part of the negligence of the doctor and nursing home.
There is also a finding that the patient party has taken
No.
away the documents from the
Document,
nursing home.
some relevant documents has not been annexed here with. It's a false document, not tallied with the documents I supplied. Yes.
Lordship, these documents which your lordship is now referring as not found there.
Sensation. Generalized swelling of the whole body.
এই ডকুমেন্ট আমার মক্কেল যা বলছি এই ডকুমেন্ট
আরে ভাই আপনার মক্কেল ফাইল করেছে
এই যে এটা ফলস ডকুমেন্ট আমাদের ডকুমেন্টস মিল না এইটা ফল লিখে আমার ক্লায়েন্ট লিখে দিয়েছে ফলস এফিডেভিট করে ফলস ডকুমেন্ট দেয় কি করে
That left is also X-ray for Urimax.
না অ্যানেক্সে কিছু ছিল না, এটাই ছিল শুধু।
2 units of blood required. Yeah.
Lordship kindly comes to another document at page 134.
This is a surgeon, says no surgeon.
সার্টিফিকেট ডাক্তারবাবু সার্টিফিকেট
Conservation manager. We are created, which we discharged. Just করেছিলাম তো।
My lord, there is another document, my lord will kindly see.
The hospital.
থেকে নেওয়া একটা সেকেন্ড
Blood report. The nursing home does not have a laboratory there.
No, it's in Burdwan, my lord. It doesn't have that much of facility. Lordship, kindly one paper, Lordship, kindly
But the
looks
thing
at.
is, now that the order has been given effect to and put in the gazette also, let that status quo continue for three weeks.
Well-
You will direct your appeal to be finished within 3 weeks. Because to restore it for gazette publication itself.
They will make a republication.
No, it will take 2 months. Gazette
No,
publication.
no. If it sends today, tomorrow the gazette publication will be done. They publish with remarkable speed. In other matters also, I will show records from this honorable court.
But
Lordship, another thing, page 134, kindly has a look. 134
May
of my
I
stay
be allowed
petition.
to
Please,
make it one submission?
134 before that. Lordship was referring that the diabetes portion, it was explained to him at the time of discharge. The patient's son has signed in that paper. And now the allegation is made that he was not diabetic. Page 134. This is the record I have obtained from the Consumer Forum, submitted by them. Kindly see page 134. Dr. Babu's certificate, it's in Bengali. I'm sorry, my lord, the English.
No problem.
It's signed by Shiva Prasad, his son. Lordship sees in the middle, AKD, that is acute kidney disease, CKD, chronic kidney disease, and T2DM, type 2 diabetes mellitus. It's written there. It was explained to the patient's son. He has signed, and now he's saying that there was no diabetes. What prevented him from saying, sir, why are you writing this? My father doesn't have diabetes. And now, after all these years, this matter is being erected up on this issue. He has signed. It is their document. Page 134.
Please come. This intra-court appeal by the writ petitioner is directed against the order dated so and so, dated 20th March 2023 in WPA 5439 of 2023, by which the learned single bench declined to grant any interim order as prayed for by the appellant. The appellant challenged an order dated 17/2/2023 passed by the West Bengal Medical Council, by which the name of the appellant was removed from the register of registered medical practitioners maintained by the West Bengal Medical Council for a period of 6 months. Under section 25, within bracket small a, within bracket 2 I's of the Bengal Medical Act 1940. The said order further stated that in terms of section 26 of the said act, an appeal against the said order lies to the government. The
They all along knew that he had diabetes.
appeal.
Diabetes and other reports are
The short issue which falls for consideration in this appeal is whether the appellant is entitled for an interim protection till the writ petition is heard, or in the event the appellant should be directed to file an appeal to the government till the appeal is disposed of. On perusal of the order dated 17th February 2023, we find that no reasons have been assigned as to why the medical council found the appellant guilty of infamous conduct in a professional respect, leading to removal of his name from the register for a period of 6 months. Therefore, we issued an interim direction directing the medical council to place the entire file concerning the issue. Accordingly, the learned advocate for the medical council has placed the entire file, from which it is seen that based on a complaint given by the family of the deceased patient, the medical council took up the matter for inquiry and had referred to the PE committee, and the committee consisting of 5 members, consisting of 4 members, and the registrar of the council being the convener. In the original file, in the minutes of the meeting of the committee finds place, and the committee has recommended action against the committee has found the appellant guilty of professional misconduct and recommended charge sheet to be laid against him. It is a submission of the learned advocate for the medical council that when the Bengal Medical Act does not stipulate that the medical council has to assign reasons while removing the name of the appellant from the register of registered medical practitioners, the medical council cannot be compelled to give reasons, more particularly when it was a case of a medical negligence, and the chairman and members of the PE committee considered the entire matter and had recommended and had found the appellant guilty of misconduct in professional respect. As pointed out earlier, the order dated 17/2/2023 communicated to the appellant does not state as to why the appellant has been found guilty of infamous conduct in a professional respect. The charge sheet which was directed to be filed is based upon the finding rendered by the PE committee. Therefore, we are of the view that the findings need to be communicated to the appellant so that the appellant will be aware of the basis on which the basis on which he was found guilty, and also what led to the recommendation of the committee for issuing a charge sheet. Unless and until the minutes of the committee are communicated to the appellant, the appellant will be at a loss to understand as to what was the basis for initiating disciplinary action against him. Therefore, we are of the view that the medical council should communicate the minutes of the meeting of the PE committee to enable the appellant to question the correctness of the said report, which ultimately led to the order of punishment dated 17/2/2023. So far as the issue as to whether the appellant could have challenged the order dated 17/2/2023 in a writ petition, we are of the view that the appellate remedy provided under the Bengal Medical Act 1914 is an efficacious remedy. And since disputed questions of fact are involved, it is advisable for the appellant to avail such an appellate remedy, as the case cannot be decided based on affidavits in a petition under Article 226 of the
My lord, I
Constitution.
had challenged it on the limited question because the reasons were not given.
Therefore, we are of the view that the appellant should be relegated to the appellate remedy. As rightly pointed out by the learned advocate for the appellant, that already 2 months have elapsed and the appellant's name has been removed from the register. And by the time and in the event, the appellant has to file an appeal or appeal to the state government, or this appeal, this intra-court appeal or the writ petition is to be heard, the punishment, the period of punishment, would expire, and the entire proceedings will become infructuous. We are conscious of the fact that if the appellant has to be relegated to avail the appeal remedy, the appeal cannot be allowed to be rendered infructuous by efflux of time, and therefore the appellant is required to be granted an interim protection till the appeal is heard and disposed of. Furthermore, we find that the PE committee inquired into the complaint after 1.5 years of the incident, and this is also one more reason which has convinced us that the appellant should be granted an interim protection while relegating the appellant to the appellate remedy. In the result, the appeal as well as the writ petition are disposed of by directing the West Bengal Medical Council to communicate the copy of the report of the PE committee, namely report of the PE committee.
My lord, may we have all the minutes, copies of all the minutes? We don't have
file number 90-C/2070 and the deposit and the copies of the depositions which have been which are annexed to the report, and the other material documents which were placed before the committee. The entire set of documents along with the entire minutes be furnished to the appellant within 3 days from the date of receipt of the server copy of this order. The appellant is granted 10 days time to prefer an appeal to the state government from the date on which all the documents are furnished to the appellant in terms of the above direction. The appropriate authority of the state government is directed to take up the appeal for consideration and decide the same on merits and accordance with law within a period of 15 days after affording an opportunity of personal hearing to the appellant, till orders are passed by the state government in terms of the above direction and within the time stipulated by this court. The order dated 17/2/2023 directing removal of the name of the appellant from the register of registered medical practitioners shall remain stayed, and the West Bengal Medical Council is directed to restore the name of the appellant in the register of registered medical practitioners within 2 days from the date of receipt of the service copy of this order, and such restoration shall be published in the district gazette with a rider that this is subject to the outcome of the appeal to be filed before the government against the order dated 17/2/2023.
My lord.
We make it
only
clear
one-
that we have not gone into the merits of the matter and it is open to the appellant to canvass all points in the appeal petition.
Deeply grateful, my lord, deeply grateful.
But when they restore it, they will say it's subject.
Yes.
Direction is given to
My
all the
lord,
documents.
Lordship, one indulgence. Lordship has mentioned personal hearing. Lordship, kindly clarify that he would be able to take the assistance of his lawyer.
No.
My lord, otherwise, my lord, he will again.
The relevant documents also the complaint, my lord.
Kindly remove the word
Yes, but
personal.
so far the proceedings before the council.
Kindly remove the word personal there.
Lawyers are allowed.
An opportunity of hearing will be
No,
sufficient.
lawyers are allowed.
Kindly remove the
Before
word
the council,
personal.
before the appellate
My
authority.
lord, if that again that point is taken, that personal hearing, you have to appear in person. You
It is
cannot.
better. It is better if he appears.
No, he will go, but he will be assisted by an advocate.
No.
My lord, direction also is given, my lord, to relevant documents to supply also the complaint. That is the respondent number 3. My lord.
Make a request.
No,
to-
under the rules, if
In
they
his-
ask for, we will
And also,
supply.
my lord, to appear and at the time of hearing also to appear before the council. My lord.
That the appellate authority will dispose of.
No, in the, if it is not directed by your lordship, my lord, suppose my lord.
Return. Record করে দিন। The original file was produced before this court for inspection is returned to the learned advocate appearing for the council.
You just find out that. Next.
Item number 4.
I filed the affidavit of service. Why CRPF was directed to be implemented?
My thing is, your lordship, may I just take your lordship a step back? The learned judge in an earlier order specifically said that initially he passed an order for providing security because he was under a feeling that the writ petitioner was under the feeling that his life is in danger because state has started various cases against him, so he is being victimized. So the learned judge initially directed to let him come from Maharashtra, and we Calcutta police will give him protection. Will take him from here to Bankura, and the entire time that he's in Bankura, local police station will give him protection upon payment of costs. And this, however, this portion from Calcutta to Bankura, Calcutta police will give that protection without cost. Very well, we complied with it. Thereafter, ultimately, the matter was disposed of by directing that if he has any threat perspective, he'll complain to the local police station. And even if he wants, he can engage his security staff, private security. That is there. The writ petition disposed of. But he's got habituated to having the pleasure of having state security. He files another letter after letter. I shall show to your lordship. Please provide me security. So we ultimately replied to him and said that no, the question is the order has been vacated. No further security. So thereafter he files another application. Again, the learned judge said, give him 2 constables as security. Now, he has no threat. There is no, the local police has not calculated any threat perspective. Nobody has, but he wants to flounder with his security over here. But he may be a moneyed man. He may be paying the cost. That's a different thing altogether. But today it is not that because
there are several FIRs against him.
Yes, there's several that he's got stay, he's got bail in them. I am not on that. But today he has a criminal background. And this cannot be a lollipop given to somebody having 2 constables around, 3 constables, because he can. And on the last order, if your lordship says that I specifically mentioned that there is no threat perspective. Then the learned judge thinks of giving him protection to CRPF and he's directed CRPF be added to the party. This will not greatest of respect. Will not is.
All right, now that is one limb of the order. And another direction is to continue to provide
the security.
But that you can seek for modification after they file an affidavit. You can establish that there is no.
That may be, but today, how long will it? Your Lordship, I just one more short point. Today, when the learned judge disposed of the earlier matter, I shall take your Lordship through that order. He specifically, the learned judge's order was that if there is any threat, please lodge a complaint. Has a single complaint been lodged? The answer is no. So what is this security for? Today he has not. I have annexed over here letter after letter. Which is
No, the writ petitioner is a politician, is it?
No, he's not a politician. He has a political backing. He may be involved, but not a politician. But he may be one, maybe involved.
But all our cases are NDPS cases.
There are large number of cases. Well, I am, but my only my.
All right, we have heard Mr. Amitesh Banerjee. Mr. Amitesh Banerjee, learned senior standing counsel, senior counsel appearing for the state. It is submitted that in an earlier writ petition filed by the respondent writ petitioner, direction was issued to the writ petitioner to lodge a complaint in the event there is a threat perception. And thereafter the matter to be considered for as to whether police protection has to be given to him or not.
Page 457 is the continuation of the order which starts at 456.
In WPA 7139 of 2020, dated 11/2/2020. The said order is quoted here and below, page 456 and 57 and 57. The present writ petition, in the present, where is the prayer in the writ petition? In the present writ petition, the petitioner seeks for consideration of his representations dated 16th June 2022, 25th July 2022, and 19th October 2022, and provide security to him and his wife for visiting their native place in the state of West Bengal. Semicolon to provide, to direct the respondents 2, 3, and 4 in the writ petition to provide particulars of all cases registered against the writ petitioner's husband, date of the order, etc. Semicolon to initiate an inquiry against inspector in charge, police station Raipur, district Bankura, for intentional and willful disobedience of the order and direction of this court. In the said writ petition, an interim order was passed on. Where is the first interim order?
Well, initially, first interim order, is page 454.
Interim order was passed on
Annexure C, page 450.
On 13/8/2021, which is to the following effect. Page number 454 and 455. It appears that in terms of the above order, security has been provided to the petitioner and her husband at the cost of the petitioner, except for the trip from Kolkata to Bankura for the first time. When the matter was subsequently heard by the learned single bench, by the impugned order, while directing the state to continue to provide security as ordered earlier, the learned writ court has directed the Director General of CRPF be added as a party respondent in the proceedings. It is not clear as to why CRPF has to be added as a party in the writ petition. More particularly when there has been a direction, there was a direction issued to the writ petitioner to file an affidavit detailing all the incidents which established the threat perception and fears of the petitioner. Therefore, unless and until the same is decided by the learned writ court, the question of adding CRPF as a party to the writ proceedings may not be necessary. Therefore, that portion of the order passed by the learned single bench dated 5/1/2023 is set aside. However, the direction to the state to continue to provide security.
But this one also, there's no threat perspective, my lord.
To provide security shall continue till the court decides, till the writ court decides as to whether there is a genuine threat perception for the petitioner and his wife, for which the petitioner has been directed to file an affidavit. Let the writ petition be listed before the learned single bench. When was it supposed to be listed?
But it was supposed to be listed a long time back.
5/1 listed before the learned single bench on in the first week
After
of
3 weeks of
first week of May 2023. The first one we have heard so and so. Though respondent has been served and affidavit of service has been filed, none appears for the respondent. The appeal stands disposed of with the above direction.
Would your lordship direct the superintendent of police to file a report before the learned single bench, giving the threat perspective?
You make that report, keep it ready.
Because my lord, my case is there is no, but my lord, today 2 of my constables have been blocked.
Next.
Item number 5.
I'm for the private respondent.
My lord, I am for the appellant. My case is that I am a owner of the property in question, and the private respondent carries out a beauty parlor in that place. I lodged a complaint before the police authority. My complaint was in twofold. One was the private respondent in carrying on unsocial activities in the premises under the guise of beauty parlor. And my complaint was that the private respondent is using a manufactured document as genuine one. And the learned, the honorable single bench, my 2 complaints was not considered and simply stated that this is a private dispute. This is
what is the police complaint? What is the complaint you have lodged? He
my
cannot examine. Suppose unlawful activities carried on.
unsocial and unlawful activities is
They
carrying out
will
under
conduct a surprise raid and they'll find out if there is illegality. They will register a case. Whether he is the owner of the property, your document.
No. I am admittedly, I am a owner of the property. My lord, kindly.
This is the landlord versus tenant.
No.
And we have already.
That is correct.
No.
But what he alleges is
My
Totally wrong.
my lord, kindly come to page number 92, annexure P6. Here I have
This is
annexed
report,
the
my lord,
deed of
collected from
conveyance.
the police.
By virtue of that, I am the
you enjoy the property. If he is
I am the absolute owner of the property.
if he is interfering, you file a civil suit.
Civil suit is pending, my lord.
My lord, annexure P6, page number
But
92. I have.
we can't go into that. The allegation in the you're for the state, madam.
Yes.
The allegation is some unlawful illegal activity is going on in the premises.
Yes.
To that extent, at least you can consider.
As your lordship would be pleased.
And another, my second point is, second point is, they are using a manufactured document as genuine one. And the police, the police submitted report on the and in the report they have annexed a
unregistered, unstamped document by which, my lord, the private respondent is claiming that they have produced a document, my lord.
Now a suit has been filed for recovery of rent.
No,
Ah.
eviction, last position by the erstwhile landlord from whom the applicant have
My lord-
purchased the property. The suit is pending. Well, I am running the business from last 23 years. The sole intention is to evict me without due process of law. This is a police inaction case, my lord. And now they're deciding title here in the writ petition.
Yes.
And see the
But
prayer.
what happened to the complaint given by the?
My lord, they have
lord,
the
my
license, they have
complaint-
showed the license.
My-
and
my-
lord, they
my-
are
Sorry, sir, sorry.
And they are depositing rent
You agitate everything in this.
before the rent controller, they have depositing the.
This intra-court appeal is directed against order dated 13/2/2023 in WPA 9919 of 2022. The writ petition was filed alleging police inaction. The complaint given by the inaction in as much as the complaint given by the appellant has not been acted upon by the respondent police. The allegation was against the ninth respondent, stating that the ninth respondent is carrying on certain illegal activities in the premises. Apart from that, it is contended that the ninth respondent that sale documents have been forged and fabricated. Admittedly, civil dispute is pending between the parties.
My lord, there is no civil dispute with me.
No, admittedly, a eviction suit is pending.
That is my erstwhile owner.
Initiated
Yes,
by
I
the
have not
erstwhile
filed
owner
civil
of the
suit. I have
property
not
from
filed.
whom the appellant alleged to have purchased the property. The learned advocate appearing for the respondent state submits that the ninth respondent is running the business after obtaining a license. In the facts and circumstances of the case, as rightly held by the learned court, it is purely a private dispute between the appellant and the ninth respondent, and no writ of mandamus as sought for can be issued in the instant case. Needless to state that if there is any illegality committed by any party, it is always open to the respondent police to take action in accordance with law.
I'm grateful.
Dismiss. Okay, next.
Item number 6.
I beg to appear on
Appellant.
I beg to appear on behalf of the appellant. Lord. There's a delay of 18 days, Lord.
My lord, in this matter, I'm appearing on behalf of the respondent number 1 and 5. My lord.
Lord, this is my affidavit of service. Lord, what happened, Lord? The writ petitioners appellant before your lordship, out of a Lord political vendetta, Lord, the Pradhan, concerned Pradhan of the Gram Panchayat, Lord, standing over there, Lord, have disconnected, Lord, rather, Lord, the electric meter is being broken down by some political persons, Lord. Complaint was being lodged, stating that in front of the Lord Pradhan of the concerned Gram Panchayat, out of a political vendetta, the electric meter is being broken. Lord, I applied for repair or restoration of the connection, Lord, before this WBSEDCL authorities. Lord, since they have not done anything, Lord, the writ petition was being filed before this honorable court. This honorable court initially directed, Lord, for exchange of affidavits. Lord, in the affidavit, the Lord private, Lord, the WBSEDCL, Lord, have disclosed that they are duty bound to, Lord, give the electricity, Lord, up to the Lord meter board position. They are duty bound. And since that is being done, so Lord, there is no duty on their part.
Internal wiring.
It is internal wiring. But Lord, the initial complaint everywhere I have stated, Lord, my electric meter is being broken. Lord, they have not even inspected what is the position. If my electric meter is itself broken, Lord, kindly takes up now, Lord, the impugned order once. Initially, Lord, some party, Lord, wanted to intervene, Lord, citing that they have some civil suit filed over there and injunction is there. Learned single judge has not noticed that since this is in respect of a different plot, so they are not a necessary party. That was being turned out. And thereafter, Lord, the writ petition, Lord, internal page 3 of the impugned order before your lordship, kindly takes up, Lord, the last paragraph. Learned counsel appearing for the WBSEDCL placing reliance on the paragraph 13 of the affidavit in opposition used by WBCL today. Submits that specific stand of the WBSEDCL is that the consumer did not get a power supply at her premises due to the fault of their wiring installation. Whereas, Lord, my initial complaint in 2021 that they have broken the electric meter.
No. Does the report say that the meter is intact?
No, there is nothing, my lord, stated.
Your report.
But let them come
My
with the-
lord, there was a complaint on, my lord,
Have annexed.
See,
they have lodged a complaint in 25/7/2021. One power docket number 4184 94877 at 8 p.m. My lord, our personnel went there, mobile van. They inspected the electricity, my lord. The electricity is coming up to the main switch. That is the power, that the main switch where the power is given, my lord. There is only one fault, my lord. They have a fault in wiring installation.
but
That is-
in that report says the meter is intact.
My lord. My lord, in opposition, I have mentioned that, my lord. In my opposition, which has all, which learned Reed Court has mentioned here.
But show that portion of the opposition where you say that the meter is intact.
No, my lord, they have given us
There are two issues. One is up to the meter or the main box. You'll have to ensure that it is your property. If he does any mischief in that, you can charge him. From there, inside the house, it is his responsibility to have a proper
My lord.
wiring.
My lord.
But your report should specifically state that the meter is intact.
No, they are saying that up to main
My lord,
switch, not the meter.
in their Reed petition, they have nowhere mentioned that the meter box has been broken.
Lord, page
But he
41
says the
Lord,
complaint.
page 41 of my initial representation, that is the docket number they have mentioned. Lord, again, Lord, I will have, Lord, this kindly excuse me, it's a Lord, Bengali written document. Lord, I have specifically stated, বর্তমানে বিজয়নগর গ্রাম পঞ্চায়েত প্রধান মাননীয় such and such মহাশয় আমাদের তিনটি পরিবারের ইলেকট্রিক মিটার বক্স গুলি পাঁচ দিয়া ভাঙচুর করে। So, my lord, it has been specifically written that in front of the Pradhan.
So if the meter has been broken, you inspect. See, if the meter has been damaged, you inspect and replace the meter.
My lord, very well, if, but my.
And thereafter, if his internal wiring is not proper,
I will take
that
care
is
of
his problem.
My lord, very well, then kindly pass an order
We'll
that
issue
inspection may be,
which authority will, which respondent?
Lord, the
West Bengal State Electricity Distribution
Station
Company
manager.
Limited.
Lord,
Station manager is Dignagar, my lord. Dignagar Nadia.
the respondent number
Station
5.
man, to fifth
My
respondent.
lord, previously we inspected there, the meter box was not broken. They are coming up with
But
a
your
new
report
thing.
is silent.
My lord, in Reed petition, they have not mentioned. They have only mentioned that they have only mentioned that their electricity is not coming. For that reason, my lord, I have filed an opposition that the electricity is not coming.
That you
within
can't
their
grant
premises.
unless and until his internal wiring is proper.
My lord, my lord.
Page 41, I have specifically written the
No,
initial.
in the writ
Reed,
affidavit,
my
you
lord.
show him from the writ affidavit. Now you are pleading a different case.
No, my lord, the initial complaint is of that they have broken.
My lord,
the
they are
electric
pleading
meter.
a different case, my lord.
31, paragraph 5 of your writ petition. That is your specific case in the writ petition.
Now you are changing your case.
My lord,
Oh,
the way
hope
they
it's
have,
not a change
they
in
have
brief.
paginated the petition, my lord, appeal, it is difficult to find out the things, my lord.
No, used bamboo pole to damage the electric connection.
That is my,
Electric line, not the meter board.
my lord, the electric line, my lord, that they have restored, but
Your
regarding
pleading,
meter-
Mr. Mukherjee, is only line.
Fix the line damaged by the private.
But my lord, the initial, my lord, your lordship knows, my lord, the initial complaint is there.
All right.
This three.
This
My lord,
May I-
they have annexed.
May I just indicate to Lordship one thing, madam? I am
Who are you?
appearing for respondent 2 and 4. Madam, in the before the writ court, an application was sought to be filed by an intervening party who filed a title suit and obtained an order of injunction, injuncting the writ petitioners from drawing the overhead line from their premises.
Okay.
Their grievance is that now they have a one-story building. Suppose they want to raise the building to two or three story, then the overhead line will be causing a prejudice. What was the submission was that you draw electricity line, but not overhead my premises. For that reason, an injunction order was obtained and order of injunction is still in force. An application for addition of party was taken out. That application on addition of parties was taken cognizance by the Honorable Single Judge, but the Honorable Single Judge held that since the order of injunction is in connection to a different property, apart from the property of the writ petitioner, so he is not a necessary party or a proper party. But the sum and substance that the order of injunction remains that he cannot draw the overhead line from over my properties whereas the suit is pending.
We will not go into that controversy.
This is not. My lord, one thing more, my lord, they are not coming with clean hands. Why, my lord? Because they have annexed the opposition of the respondent number 1 and 4, 2 and 4, but the opposition which I have filed, they have not annexed.
I am carrying with that opposition.
My lord, my writ petition is there. They have not.
This intra-court
appeal is
appeal
there,
by
they
the
have
writ
not
petitioner
properly annexed.
is directed against the order dated 2nd January 2023 in WPA 12588 of 2021. The writ petition was filed alleging that some private parties have damaged the electric line, and a complaint in this regard was given to the 5th respondent. And alleging that no action was taken, the writ petition was filed. The learned single bench had disposed of the writ petition with certain observations, also taking note of the fact that observations, and granting liberty to the appellant to approach the competent civil court where litigation is pending against the appellant and obtain appropriate orders for carrying out necessary repairs to the wiring installation inside the appellant's premises. Before us, the learned advocate for the appellant puts forth a different case, alleging that the electricity meter had been damaged by certain miscreants, and that was the complaint lodged with the 5th respondent, and the same has not been considered. We find from the affidavit filed in support of the writ petition that no such averment has been made, and the allegation is only with regard to the alleged damage to the electric line. The report submitted by the 5th respondent before the learned writ court, shows that the electric line inside the premises of the appellant is not in good condition. If such is the fact situation, the appellant cannot claim that he should be granted electricity supply when the electrical installation inside his property, inside his house, does not meet the required standards. In any event, if there is a damage to the electric meter, it is a serious matter, and the meter being a property of the board, the same has to be ensured that it has to board, it has to be ensured that there is no damage to the electric meter. Therefore, while not interfering with the observations or directions issued by the learned civil bench, we direct the 5th respondent to conduct a surprise inspection of the premises just to ascertain if there is a damage to the electric meter. And if there is a damage, necessary action be initiated in accordance with the relevant regulations. In all other respects, the order passed by the learned single bench is confirmed.
I'm extremely grateful.
Next.
Item number 7.
Item number 7, I am for the appellant petitioner.
There was a delay, 18
Ah.
months delay.
Delay, we have heard the learned court. We are satisfied with the reasons given in the affidavit filed in support of the petition, and the delay in filing the appeal is confirmed.
There, I am the appellant petitioner. There is the dispute with regard to pathway. The police is harassing the petitioner. Petitioner approached before this honorable court earlier. The court directed the police to not to interfere with the civil right of the parties. Now, my lord, what is happening in respect of that, my lord, the pathway? There is an incident of 25th of December 2022. The petitioners and his brother was taken away by the police, and they are beaten up, my lord, severely in the police station and even in the spot. Everything was, my lord, videographed by the petitioner's brother. And my lord, there have been, my lord, the petitioner was, my lord, became unconscious. He was, my lord, transferred to the hospital, and my lord, thereafter he has been, my lord, taken, my lord, he was taken in a case which is the bailable offence. All are the bailable offence without serving any notice under section 41 of the CRPC. Now, my lord, I lodged the complaint that is at page 65, and the relevant portion of the complaint is page 67. My lord, your lordship kindly see the complaint before the superior authority to initiate, my lord, action against the police authority. Page 65 and may I just read, my lord, page 67, my lord, the internal page 3, internal second page. I state that I and my brother Haradon Noskar were taken into the Motrapur station, police station by the sub-inspector of Motrapur police station, wherein I was beaten by the said police officer. The said police officer kicked me and beat me very roughly, beaten me roughly, and due to the said assault, I become unconscious on the plea and I resisted erecting of illegal pathway on the Sanjay Gan and his family member. Then
Now,
I was
what happened to this complaint to the
now,
superintendent?
no steps was taken, my lord. On the basis of my complaint, my lord, since no step was taken, I approached with this honorable court. And my lord, my pair is, my lord, kindly see my writ petition pair. My lord, kindly come to my pair. That is at, my lord, page 37, my lord, pair B.
Now, what did the report? What is
The
the
court says that since there is a civil dispute and pending before the civil suit, you go to the remedy before the civil court. My lord,
Now,
page,
who appears for the state? You are but if suppose it's a case of police excess in the police station, at least the superintendent of police can inquire additional.
On the arrest, there was a previous FIR. In the previous FIR, that is of 8th of December 2022, section 41 notices were issued on 3 occasions to the petitioner. The petitioner was not appearing. That is with regard to the earlier FIR. Now, on 25th of December, there was some allegations with regard to hot altercation in the area. When the police approached, they found that the petitioner and his brother is involved in the hot altercation, and there were allegations of beating up the other private respondents with.
No, you arrest them and remand them to.
He arrested. We arrested, immediately after arrest, the petitioner, complained of discomfort, which has in the writ petition, has gone into the allegation, of torture, beating up. Immediately we took him to the medical officer, and the medical officer, after checking him up, said that he is medically fit. Those certificates and the 41A notice, the 2 grievances that he is canvassing, both I have brought, for your lordship's perusal, in 41A notices were also given. And after the complaint of physical discomfort also, they were produced before the medical officer.
The hospital doctor certified that he is hale and healthy.
Clinically fit.
My lord, your lordship, kindly see, I pay for, my lord, kindly see, my lord, page 67, what I am pay for. My lord, that I was admitted in the hospital after recovery for the condition, I was released from the hospital. As taken by the police, it is pertinent to mention on the date I was supposed to sign certain blank document. If you see the CCTV footage of the police station, everything will be clear. That on the next day afternoon, I and my brother was sent to the London Magistrate Court and Diamond Hour. My lord, you are to kindly see these all the allegations as billable offence. In the billable offence, my lord, a person who has been arrested will immediately he can, my lord, release on personal bond. So I am arrested and released on the, my lord.
This intra-court appeal by the writ petitioner is directed against the order dated 20th March 2023 in WPA 3455 of 2023. The said writ petition was filed by the appellant, praying for appropriate direction to the superior police authorities to inquire into his complaint/representation dated sent by speed post, not dated. Sent by speed post on 18 January 2023. The sum and substance of the allegation in the representation is that the petitioner and his brother were beaten up by the sub-inspectors of police of Mathurapur police station. And the petitioner and the appellant became unconscious, taken to the hospital. And after he was discharged, while he was discharged, he was forced to sign certain blank papers. And the appellant claims that if the CCTV footage is seen, everything will be clear. The learned advocate appearing for the respondent state submits that after the appellant and his brother were arrested, the appellant had appellant expressed certain discomfort, and therefore he was taken to the hospital, and the doctors have examined him and have certified that he is physically fit. Further, it is submitted that notices under section 41 capital A have also been issued. In any event, no, sorry. This submission made by the learned advocate for the state is at the on the instruction given by the respondent police. However, the allegation is that the respondent police had committed certain excesses against the appellant, inflicted bodily injuries on the appellant and his brother. If such is the allegation, it will be necessary for the higher police official to examine as to whether there is any merit in such an allegation. Therefore, we are of the view that the complaint lodged by the appellant has to be looked into by the fifth respondent, namely the additional superintendent of police, Sundarban Police District, office at Polahat, PO, and police station Kakdeep, Gateshwara District, South 24 Parganas. Accordingly, the appeal stands disposed of by directing the appellant, directing the fifth respondent to consider the complaints as representation given by the petitioner, which was sent by speed post on 18th January 2023. The appellant is directed to forward a copy of the said complaint along with a copy of this order to the fifth respondent to take appropriate action on the same. Necessary action be initiated in accordance with law within a period of 3 weeks from the date of receipt of the copy of the complaint.
Fourth respondent is the superintendent of, fourth respondent is the superintendent of police. Respondent of 4 is the superintendent of police.
The officer in charge, the inspector in charge of Mathurapur police station is directed to preserve the CCTV footage.
That I'll have take
As
instruction
it
of
has been
26th
alleged by the
December.
petitioner that the entire incident has been captured in the CCTV installed in the police station.
That this is of 4 months back, so I'll have to
CCTV
take
footage
instructions with regard.
may be looked into by the concerned fifth respondent while deciding the allegation of the petition.
Kindly makes it if available, because 4 months have gone by. Today we are 4 months.
Whether at all the CCTV was functioning.
That I'll have to see,
Let us see. You take
We
a
have
defense.
some videographs on the date of incident, my lord. We have some videos. Kindly allow me to produce that at the time of my lord, the inquiry. Because
The appellant is at liberty to produce
videograph is of the
materials or
pathway.
evidence which he may possess before the fifth respondent.
The videograph petitioner says in the petition is in the dispute in the pathway, common pathway.
on the path, on the spot.
That is injunction is there. Let us see.
Deeply obliged.
Item number 8.
This is a writ appeal, mandamus appeal arising, my lord, on behalf of the private respondent. Lord, before troubling lordship with the paper, private respondent is the registered proprietor of a trademark of 7 trademarks. She is the recorded proprietor. Under the Trademarks Act, as your lordship knows, registration confers an absolute right to the registered proprietor to sell and use the trademark. That is section 29, 1 of the Act, read with section 29, 2, 3, 4. That's the absolute right. And in all legal proceedings, registration is presumed to be valid. Today she is as a proprietor. The respondent, number 6, the respondent, primary respondent here is who had filed a writ petition. Had purchased the company called Duckbill Drugs in a liquidation proceedings. They were the successful resolution applicant. They purchased it. They contend that these trademarks in question were part of the liquidation assets as defined under section 36 subsection 2 of the IBC or the insolvency and the bankruptcy code. They purchased it, e-auction notice, sale is on as is where is basis, whatever there is basis, and without recourse basis. So it's as a going concern. The proprietor on the basis of the deed of assignment, which is April 2017, which my learned friend says is a forged document. Says the assignment could not have been taken into effect because this is not a proper document. Or this was notarized, everything done in 2017, and it was put into application was put into on January 2022. So the application was put in, it was registered in June 2022. So this was, my lord, what was done. So, my lord, she becomes a registered proprietor. My learned friend thereafter, my lord, filed a writ petition before this court in November, my lord. The dates are very important. November 2022. It was not moved. My lord, the writ petitioner, my lord, the appellant, my lord, filed a suit for infringement of the registered trademark, my lord, before the district court. They got no order. On an appeal therefrom, the division bench, my lord, granted an order, my lord, restraining, my lord, the duck-billed drugs, my lord, who had purchased the property from using those trademarks on reliance of section 29 of the Act. In the meantime, also in November, my lord, the application under section 60 subsection 5 under the IBC was filed in the self-same relief, my lord, before, my lord, the company tribunal, the NCLT, my lord. That is, my lord, pending. Self-same. What is spread in the writ? That is spread in the writ. My lord, the matter was taken up, my lord, after the order was subsisting by the division bench. They, my lord, mentioned the matter. My lord, and my lord, the matter was taken up on 29th of March, my lord, 2022. My lord, when, my lord, showing the urgency. My lord, the urgency, my lord, after 6 months, which my learned friend, my lord, had so-called urgency. My lord, it was moved, my lord. My lord, preliminary point taken, my lord. November is the date. They, my lord, mentioned in on urgency. It was moved, my lord. Preliminary point taken, my lord. There is an alternative remedy. What is the remedy, my lord? Remedy is, my lord, section 57 of the Trademarks Act. If any person is aggrieved, my lord, with the registration, my lord, he has a right, my lord, to, my lord, go before the registrar and have the mark cancelled. Any person. And if any person is aggrieved by an order of registrar, he can come up in an appeal to our IP division, my lord, under section 91 of the Trademarks Act. Because good, bad, indifferent, my lord, there is an assignment. The assignment deed says it's with goodwill of 7,000 rupees. Whatever is the value, it's with goodwill. Now, a registered trademark, I will show, my lord, trademarks can be assigned if a registered trademark as well as an unregistered trademark can be assigned with or with the goodwill. If it is with the goodwill, prima facie there is a deed which record says it's a goodwill. Well, there is no time limit for recordal of assignment. This is under the Act. The learned judge, my lord, overrules, my lord, the objection taken. My lord, it's very unfortunate. My lord, when the, my lord, I was not there on the returnable date, my lord, when it was argued, it was missed out. It was missed out, my lord. That naturally, my lord, that there's already a section 60 subsection 5 application there. I'll show, my lord, identical reliefs before the NCLT, my lord, which is pending. So, my lord, this, my lord, she did not, my lord, take into account on the ground as recorded in the order that these documents were not produced at the time of when the argument was heard out. Yes, that's recorded in the order. So, my lord, but all fairness, my lord, if the writ is, my lord, after, my lord, 6 months, after filing after 6 months is moved, my lord, one day, my lord, deferring and considering the document, my lord, nothing, my lord, would have, my lord, turned the events, my lord. But, my lord, alternative remedy availed. Section 60 subsection 5 under the IBC, this is on record. My lord, section 57 application not filed. My learned friend files a writ petition. And my lord, the learned single judge,
the prayer was to revoke the assignment.
Revoke the assignment. My lord, that's a separate statutory remedy, my lord, under section 57. When there is specific statutory remedy under section 57, could the writ court, my lord, have, my lord, invoked? If, my lord, my learned friend falls back on IBC saying it's a liquidation estate, it's section 60 subsection 5, which is on record.
Now, what has the writ court done?
My lord, restrain me, my lord, restrain the registered proprietor from using the mark. It is unheard of. Can a registered proprietor be restrained? It's contrary to the Act. And, my lord, the point of maintainability, my lord, has been decided, my lord, against my lord, the, my lord, private respondent. These points were clearly taken. Kindly, my lord, kindly have a look at the order once, my lord. Kindly look at the order once. My lord, deed not yet acted upon. It's not a proper deed. It's a backdated deed. Can the writ court, my lord, adjudicate these questions? My lord, kindly take the order, which is, my lord, 6th of April 2023.
Yes.
The memorandum of appeal. May I just place it, my lord?
Yes.
The petitioners claim to be in the business of manufacture and sale of pharmaceutical products. That is, my lord, who is the successful resolution applicants, my lord. And the auction purchaser of 14 trademarks through a public auction contended under the provision of the insolvency and the bankruptcy code. The petitioner prayed for a writ of mandamus against the trademark registry Kolkata to revoke an assignment of the 14 of the said trademarks in favor of the respondent number 6, and also to restore the trademarks in favor of the respondent number 3 being a company which went into liquidation on 13th of April 2021. Before the proceedings, the parties should be described the relationship with each other. The 14 trademarks were owned by the respondent number 3 Drugbill Drugs Private Limited, which went into liquidation by the order of the NCLT dated 13th of April 2021. The trademarks relate to a medicinal products. The trademarks were the subject matter of a e-auction shell notice published on 23rd of April 2022 as a part of the public auction of the sale of the respondent number 3. Drugbill Drugs Private Limited is a going concern under the provision of IBC. The petitioner number 1 participated in the auction and was declared as a successful bidder. The sale certificate was issued by the respondent number 1, who was the liquidator at that the relevant point of time in favor of the petitioner number 1 on 11th of May 2022, confirming the sale to respondent number 3 as a going concern, including the asset mentioned and the sale certificate. The sale certificate mentions the trademark registered in name of the company include the 14 trademarks. The petitioner, however, came to know later that 7 out of the 14 trademarks in the sale certificates were registered in the name of the respondent number 6. Now, Millard, kindly.
Sixth respondent is the appellant.
Yes, appellant before the Lordship, Millard, the lady, Millard. The petitioner came to know, Millard, that the 7 trademarks were assigned in the petitioner for a deed of assignment for a value of 7,000. What the learned single judge, Millard, with defect of respect did not record, Millard. The assignment, Millard, is with a goodwill. The deed, you have to proceed in a writ court. You have to proceed on the deed. It says with goodwill means it's with goodwill. You cannot go beyond that. That will be on a trial. The respondent numbers 4 and 5 were the erstwhile director of the respondent number 3 company in liquidation is the daughter-in-law of the respondent number 4. A short backstory to the writ petition must be told. The learned judge Miller takes note of it. The respondent number 6 filed a title suit in Alipur court in November 2022 against the respondent number 3 company in liquidation. The respondent number 6, the plaintiff before the Alipur court came for a declaration that the respondent number 6 is the registered proprietor of the mark and the permanent injunction from infringing and misappropriating the intellectual property trademarks of the respondent number 6. Upon failing to obtain an interim order of the court, the respondent number 6 filed an appeal to this court. The division bench, by an order dated 24 January 2023, restrained the respondent in the appeal, the respondent from using the concerned trademark till 31st March 2023. By an order dated such and such, the interim order has been extended 4th of. The petitioner has applied for vacating of the interim order. Now, my lord, kindly take the next bit. The learned counsel appealing for the respondent number 6, with the assignee of trademark, raised a preliminary objection as to the maintainability of the writ petition. The objection relates the petitioner having an alternative adequate remedy. Under the Trademarks Act, the learned counsel appealing for the respondent number 6 submits the petitioners have a statutory recourse under section 92 of the Act, where a person aggrieved by the order of the registrar may file an appeal to the High Court, and also under section 57(2), which provides that any person aggrieved by entry in the register with sufficient may apply to the High Court of the registrar for expunging the marks. Counsel submits the petitioner as seeking to set up the division bench against the inviting the order, which will be inconsistent with the division bench. Next page. The preliminary objection first is dealt with. Setting up of a court, another is in an statute. It presupposes an earlier and not a later proceedings. The chronology is important since the charge of abuse is made on the later entrant to the proceedings, where the subsequent proceedings is alleged to invite a conflict of the order, and a conclusion in a direction which is proceeding is meant to take. In the otherwise, a litigant takes a chance to obtain orders from the court in face of the existing order, obviously of not liking of the litigant who had filed the proceedings first. In the present case, the charge of abuse giving birth to multiple litigations in respect of which is subject matter of dispute is on the petitioner but not on the respondent number 6. But I got a successful order on the petitioner but on the respondent number 6. Have you said the petitioner filed a writ petition on 14th of November 2022. Kindly marks the date, Millard. Was I not entitled to an affidavit? It's happening in now, Millard, in March, April. With the respondent number 6. The respondent number 6 thereafter instituted the title suit in Alipur court in the first week of December 2022. Upon failing to get an interim order, on 12th of December 2022, the respondent filed an appeal before the division bench on January 2023. The aforesaid makes it clear the respondent rushed to file only after the petition has filed a writ. Thereafter, the charge is contrary to the admitted facts and without basis. Now, we are kindly takes the next. The petitioner cannot be faulted for not pursuing the remedy available to them. The petitioner might have a right under section 52 of the Trademarks Act to apply for High Court for expunging the entry made in the registrar.
Sorry for interruption. What happened to the division bench?
Miller, we are fighting it there, Miller. The vacating application filed, Miller. Miller, injunction
They
is
have filed
continuing.
the vacating.
Yes, injunction is continuing. That, Miller, she records with utmost humility.
Page 9, it
Yes.
is recorded.
That's recorded. Miller, as I said.
But you are for the writ petitioners. With regard to maintainability, it's no doubt true that, it can apply to the High Court under 57(2), but not in a writ proceedings.
Correct.
See, what they ultimately, the direction to the Registrar of Trademarks is in effect a direction to a private party. By directing him to revoke would mean that revoke the deed of assignment. This daughter or whatever it is, this lady has got the assignment. And you have, of course, you have purchased the, the asset of the company. And these trademarks are also shown in the annexure, no doubt. But there is an order of injunction operating at her instance, restraining the company from using the mark.
Company at that point of time was not the owner of the mark.
But we have got a reservation on that maintainability.
It's squarely covered, Miller, by the decision of Bombay and other courts. 57(2) is an absolute part.
No.
Yes, I'm sorry, Miller. That's an absolute.
But you approaching the IP division is a different matter, or the IPAB, or before the registrar. To seek for a writ of mandamus to cancel a deed of assignment.
Can't be done.
Miller, what is troubling your lordship, let me address that first. I am an auction purchaser, is not in dispute.
Exactly.
I go before a court, the court says, look, this is all it's there for sale. I purchase it. My contention before the court there and now today is, I have paid 5 crores of rupees. Give me what I have purchased from you. It is only when the court gives me that and thereafter there is a subsequent dispute regarding that, I can go there. Today, the court is unable to hand over to me what it has sold to me. Why? Because my learned friend is trying to contend before another court that she is the owner of the mark. Importantly, my lord, in a suit, and even today, in none of the proceedings, my learned friend has come before the court and said that the registrar could not have sold the marks. She has not challenged the sale. If the sale is not challenged, my lord, then the court is under an obligation, permit me to say this, to hand over for what I have paid. And that is the trademarks. That is what, my lord, I tried to insist upon the court, that you first give me the mark. Thereafter, if I have a dispute with somebody, I'll fight it out. Today, if I go before the 557 bench, say that I am aggrieved, you are aggrieved by what? I am aggrieved by somebody else using my mark. Where did you get that mark? The court has not handed over the mark to you. It has just given you a sale certificate and is unable to, you are unable to get it registered. So you are not even the owner of the mark today.
But there is an application pending before the NCLT for.
Millard, the NCLT application that is pending, Millard, has to be by the official liquidator who will complain that this dealing of the mark during the period when this company was in liquidation was illegal. And why I say so illegal, Millard? Kindly come to page 183 once. Because before this mark was registered in my learned friend's name, the official liquidator gave a...
One issue, sorry for interruption. The learned judge has directed affidavits to be filed.
Yes.
But so far as maintainability, she has already decided.
Because of 2 reasons, Millard. Either maintainability, your lordship knows, Millard, has to be dealt by the court first before any entry.
No, not at the interlocutory stage. It can
but
be.
You can keep the maintainability point, because problem is this, Millard. Kindly see the basis.
But then how to grant and see virtually the writ petition has been allowed.
No, Millard, why I say
yes, it is allowed because by grant of an interim order, the writ petition has been allowed without
respect, Millard, with respect.
Without calling for affidavits. And affidavits were, Millard, in court. Millard, this was sprayed. Mr. Das was there.
Millard,
Please
kindly
give me chance to file an affidavit.
Once.
Have the last part, Millard. How she has dealt with it. Is this natural justice, Millard? Kindly,
of course, Millard.
Of course,
I filed it in November.
Millard,
I mentioned it up the number.
Very sorry. Millard, this court is aware of the fact that the order permitting it's sitting on the division bench order.
I'll show. And I had, in fact, Miller brought this division bench order to the notice of the court, and I had submitted, which is recorded.
Right, if you want to both of you argue the appeal, until then we will suspend this.
Miller,
order.
problem is this, Miller.
No, see, you did not use the mark. There is a division bench order of injunction operating against the company. The company has been purchased by you.
No. Your lordship is getting. This company had gone into liquidation much prior to the division bench.
Let us see what is the effect. We
Miller,
can't decide the appeal
Miller,
as it
kindly
is.
read 183 once, Miller. Page 183 once.
Yes.
This is what, Miller. No, 183. Miller, is it legible in your lordship's copy? Is it legible?
Yes, we will manage.
Miller, this has been written, Miller, by the official liquidator to the trademark registry, saying that these marks, this is to bring to your kind attention that the undersigned has been appointed. Undersigned has been appointed as an liquidator in the above proceedings.
Above mentioned liquidation.
And the above mentioned, please permit my junior to place it.
This is to bring to your kind attention that the undersigned would have been appointed as the liquidator in the above mentioned liquidation matter of Messrs. Duckbill Drugs Private Limited. The copy of the order is attached herewith for your perusal. During the course of the liquidation proceedings, I discovered that the following trademarks have been registered in the name of Duckbill Drugs Private Limited in your office. Then the list is
In
there.
view of the above, I would request you to maintain status quo with the above mentioned registered trademark and do not entertain any.
And do not
entertain any.
You are hereby requested to cooperate on
Any
the
request of transfer.
Yes,
Or
any request of
otherwise
transfer.
from the promoter, erstwhile promoters of Duckbill. In due course of time, the undersigned liquidator shall provide for further information in respect of the above mentioned intangible assets, that is trademarks of the company. Requested to cooperate.
And this sale and transfer has taken place in breach of this order. And that is what the learned judge has recorded. You could not have got it registered when there was an order on you not to deal with this.
That whether to writ court to do it.
With respect,
We will hear you on that because
Miller,
the
today-
learned judge has not kept the issue open.
Yes.
Now to say, please leave that issue open is, it may not be appropriate. So we will decide the maintainability.
Correct.
Until then, the interim order will stand suspended.
Grateful. Miller, this interim order which your lordship, the division bench order and the division bench proceedings were initiated by my learned friend once I served him a copy of the writ petition. In that writ petition, my learned friend does not say any, he suppresses.
In the meantime, probably you succeed in vacating that interim order.
In that Miller, my learned friend has completely suppressed the sale. He is completely
So
suppressed.
your affidavit is on record. The division bench will definitely.
So what the
value your
division bench
submission.
has done, division bench has stopped or restrained Duckbill.
Yes.
The company in liquidation from dealing, because the impression given to that is this company is wrongfully dealing with my company. Suppressing the fact that this company is no more the owner, it has gone into liquidation and the properties has been sold to somebody else.
I have an assignment of
No, we'll do one thing. We will fix a date for the appeal. You file a compilation if it's required.
But only thing is this, Millard, my learned friend is restrained. I am restrained from dealing with the mark in spite of the fact that I have purchased it.
In law, I am entitled
Now,
to
thing is, my
trademark
learned
that
friend,
special statute.
my learned friend has purchased this or got this registered in breach of the order of court. What the learned judge has done is said that I cannot use it very well, pending the appeal. You don't use it because you have purchased it in breach of an order of.
How can
That
be
needs
in
to be
breach of
decided
statute?
finally, sir. That needs to be.
Section
it
29.
can't- See, virtually the writ has been allowed.
Yes.
But
And I was not even allowed to file an
We have
affidavit.
heard the learned counsel's
It's
party.
unheard of.
After careful consideration of the materials placed on record, we are of the prime facie view that the nature of the interim order granted by the learned single bench has virtually resulted in the main writ petition being allowed. Furthermore, the important issue as regards maintainability of the writ petition was required to be decided, for which, in our opinion, affidavit should have been called for. The learned single bench has taken a final decision with regard to the maintainability of the writ petition and held the same to be maintainable. This, in our view, requires to be considered for its correctness, since affidavits were not on record when the matter was heard. That apart, we are required to see what would be the effect of the order of passed by the division bench in the collateral proceedings. As already pointed out, the interim order being and the order passed by the learned single bench being in effect an order allowing the writ petition at the very threshold, we are inclined to entertain this appeal and also direct the stay of the operation of the impugned order till the appeal is heard and disposed of. In the result, the appeal, for such reason, the appeal is admitted and there will be an order of interim stay of the impugned order till the disposal of the appeal. The parties are, the learned counsels are at liberty to file a compilation containing documents which are not forming part of the stay application.
Millard, only one thing, Millard, may I ask, Millard? In the event, Millard, he sells off this mark once again.
You buy her, you buy the mark from her.
I have bought it for 5 crores.
As is varies basis.
I have bought it for 5
not aware.
Without-
OL was not aware. OL was not aware when the sale took place.
My lord, I appear for the liquidator. My lord, it is not that the OL was not aware. My lord, the marks were part of the company.
No, Millard.
They were sold by an advertisement. The entire transfer has been made fraudulently post the liquidation sale.
Okay.
I'll demonstrate that from the orders and from the documents which are part of the NCLT.
Yes, yes.
So, Millard,
Entire fraudulent.
in the meantime, if he creates third-party interest,
That can-
We make it clear that that the appellant should not take advantage of this interim order
Yes.
and create any third party interest on the said trademarks.
Yes, yes.
Millard,
In fact,
Millard,
I offered
kindly-
that on the
Millard,
first.
kindly fix it. Millard, I have purchased it for 5 crores. He says I
Millard,
purchased it
with
for
goodwill,
7,000 rupees.
See, the single judge says, Millard, ignores the goodwill part from the assignment date.
8th
Doesn't
June.
give Mr. Das to file an
Let the
affidavit.
appeal be listed on 8th June.
Millard, the next matter, your lordship, I have been served with the copy of the appeal papers yesterday. If this matter could be taken up on Wednesday.
I am there, Millard. No difficulty.
No, let it remain in the list. It won't, 2:15 we have got original sale.
I can come back on Wednesday.
Today is
No difficulty. Wednesday keeps
Millard, on
it.
Wednesday.
Wednesday, where it will be, you shouldn't.
Millard, because
Millard,
I-
No, Wednesday, it may be 175,
That's
222 also.
difficult.
You don't seek for upgradation.
Millard, it's my appeal, Millard. It's
No.
my,
Sir,
it's
yes,
my
sir.
appeal. It's
Sir,
my appeal, Millard.
Let us see in the afternoon.
Arfesi,
You come back, finish your lunch, come back at 2:30, let us see.
Millard, may I beseech your lordship if this can be heard this side of the vacation? I will not take more than 15
Impossible,
minutes.
sir.
great.
I will
Sir,
not
you
take more
just-
than 15
You
minutes.
see the cost listed. I'm just, we are getting claustrophobic. 250 matters filed without certificate copy, leave granted, they are pressurizing there. And the monthly list, PILs, you come and watch the PILs here.
I know
Quality of
yesterday Millard,
PILs.
also your lordship was,
Sorry to say,
but
sorry to say. At least in a week, we get only 3 quality matters. In a week, we get only 3. And the order sheets are like your stay applications. This affidavit, this reply, rejoinder, report, first report, what is it? Objection, supplementary affidavit. And what is the allegation? Some fellow filled up a pond, water body.
Millard, the matter just previous to this one. See,
That is not a pond means, of course, there is a water body, right? And so I don't know when it will.
these are Millard all efforts to take it
These
outside.
are all commercial matters. See, this requires precedence. You have invested so much of money. And whether this, according to the official liquidator, this is a fraudulent transfer. 7,000 rupees, the daughter-in-law of the erstwhile director gets it. Lovely. Some unregistered document. All right, we'll see through it. But then, but we are not unable to do any exercise. That's troubling us, no? See, at the end of the day, when you finish a good argument, regardless the result, you go home satisfied, go to your chamber satisfied. We need to get the same satisfaction.
Of course,
Yeah,
of course. Peace of mind is very important.
In fact, speaking for ourselves,
Well, we are also happy, Millard. We come, we
And they were
prepare, we
interesting
argue, whatever
matters.
the fate is, Millard.
Much
I go
interesting.
back home, Millard. I have a chat with Mr. Dotto, Mr. Banerjee, Millard. This is what happened.
Yes, variety and interesting matter.
Yes.
In fact, Millard, I probably was the first one to argue a civil matter before your lordship.
But only one thing, Malad, may I just point out, Malad, considering the seriousness of this matter, Malad, is that these are, Malad, trademarks with regard to drugs.
Yes.
I being the liquidator, Malad, the entire onus is on me because I have, Malad, I have to transfer it. The company is still in liquidation because until I make the, Malad, dissolution report. Malad, I hope, now this is very serious, I hope during this period till 8th of June, they do not manufacture something
No,
which
no,
could
how can he
create any
get, how
problem
can he
to the
get that
entire.
stay?
I-
What,
I
Millard,
hope
this,
not,
he
because
can't get a
please-
stay. He
But I
can't get
hope,
a,
because that
how
would
can
be very
official,
serious.
well, how can official liquidator restrain? Only I will not.
No,
I
but what is
manufacturing
happening
here,
is-
no, nothing to say.
What is happening is this, Millard.
Mr.
A
Banerjee
trademark-
get an order of stay, Millard, indirectly. Lord
My-
has passed an order.
That trade is
No, no.
fraudulent.
In case
No,
I
what
do-
is happening
Millard,
is, Millard,
kindly, a
my learned
registered
friend-
proprietor can't be restrained.
No,
That's
in-
not the case.
that is exactly in challenge, that whether
But
what
challenge
the
can't
sale
be in
certificate
recourse.
which is in my favor granted by a court is valid, or an assignment, private assignment between father
But
and
it's a
daughter is valid.
registered, I am on board.
we are not on
Proprietor.
minutes. No, we are not made.
So only thing is, Millard,
Not indirectly.
what will happen is he will flood the market using this.
Yes, of
trademark.
course, it's my property.
Kindly see, he is saying so also.
It's my
That
property.
is the urgency.
It can be in May, my lord, sometime.
Because I have,
No, that's what we are discussing.
Sometime.
In fact, I've got the other division bench, that Birla Lodha matter.
Yes.
That is fixed for the last week of, just before
It
vacation.
won't take much of a time, my lord.
No, no, no.
15
Won't take
minutes.
much of a time.
Millard, alternative remedy,
It
Millard,
will take
15
time,
minutes.
Millard.
That I-
He wants to impugn
Because
the
he
in a assignment in a writ petition. It will be done first
Let
time.
it come on 8th.
Eighth.
Thank you.
My lord, may I
Grateful.
mention item 19 of May or?
No, we come back at 2:30. It's already 1:30. Come back at 2:30.
madam, I have the track record. Another copy of the letter and ask him to receive it over the letter, over that letter. When you want to forward. How can you have that copy from him? Ask anybody of your bank, come down to High Court once within 30 minutes. I'm giving you a copy. All right. That suffice. That's yes. I saw that expecting it's a habit which it's an intentional habit. মানে আমরা জেনে নিতাম আমি তো এটা সার্ভার জলপাইগুড়ি সার্ভার থেকে করতে হবে ওদের কাছে পাঠাতে হবে হ্যাঁ ওটাই নিয়ে গেলে তো হবে ওটাই নিয়ে গেলেই তো হবে আমার কাছে 4টে আছে 5টা মোট প্রিন্ট করেছি একটা দিয়েছি দুটো সাহেবকে দেবো আমি একটা রাখবো এখানে একটা দিয়েছি হ্যাঁ I had read that diversity matter.
এটা হবে মিনিট 15।
তো জানিস
তুমি কি জলপাইগুড়ি? প্রথমে জলপাইগুড়ি তুমি আছো? জলপাইগুড়ি
নেক্সট করেছি আমরা একদম এই তো রিটেক করতে এর মধ্যে রিটেক করতে দিস ইজ দি নাম্বার আমরা তো এক্সস্টিভ রিপ্রেজেন্টেশন ওটা ছিল ফর স্ট্রেংথেনিং এন্ড ওই ড্রেনেজ অফ দি NH5 পাগলা ছোড়া আঠেরোই জুলাই লিগাল নোটিশ
After the order.
না আমরা রিপ্রেজেন্ট ওইটাই তো বলছি represent- আমরা ও তাহলে আমি ওটা আগে দিয়েছি বাট এক্সহস্টিভ রিপ্লাই উইথ অল দি ডকুমেন্টস অ্যানেক্স দ্যাট ইজ ফ্রম 249 to 270. So exhaustive reply. Ah. পরে 18/7/22 লেটার এখানে লাগবে তো হয় স্যার না এখন জলপাইগুড়ি সার্কিট
কত ম্যাটার আছে দাদা?
এর ভিতরে একটা পড়তে হবে
আমার
ঠিক আছে করবি তো হ্যাঁ ওখান থেকে আসছে
Yes.
Appellate side, circuit bench at Jalpaiguri matter, item number 1.
Yes.
The IAPA for the appellate.
I appear on behalf of the state.
Well, this is against an order refusing to pass an interim order against which, my lord, we are before your lordships. My lord. But the order is of 10th of April 2023. Where a brief background of the matter, my lord. My lord, a contract was awarded to me. Where I was supposed to, my lord, some embankment rehabilitation of some embankment work.
Very good.
Now, my lord, the time prescribed for completing the work is 540 days.
540 days.
540 days from the date of issue of the work order. Number two, no objection from a particular key estate was required. Well, 300 days went for taking that no objection from the key estate. Well, the contract was awarded to me on 10th of January 2017. The NOC was received by the department on 18th of December 2017. Then, my lord, a termination order was issued against me on 30th of July 2018 on the ground that I had proceeded with only 5% of the work. But thereafter, my lord, the termination order was revoked by the respondents on 28th of March 2019.
Revoked.
Revoked. But thereafter, my lord, three things happened. My lord, a supplementary agreement was executed between the parties on 22nd of August 2019. And my lord, the completion time was extended till 22nd of August 2020.
Yes.
My lord, in view of variation, my lord, in the quantum of work, my lord, price variation was allowed twice. Once on 28th of January 2022. The second one is on 10th of February 2022.
Yes.
But in the meantime, my lord, the time to complete the work, my lord, was about to expire, my lord. We make a prayer for extension of time. But that is, my lord, on 23rd of February 2022.
Yes.
But on 13th of April 2022, where the respondents asked me to undertake some rectification work, which presupposes that the contract is continuing. Five days thereafter, that is on 18th of April, where the authorities say that please don't execute any work unless the time is extended. But this is said, my lord, on 18th of April 2022.
Yes.
But after 9 days, another letter on 27th of April 2022 saying that I must adhere to the previous letter of 18th of April. That is, without extension, I should not carry out the work. My lord, while this was going on, my lord, on 5th of May 2022, my lord, they take a decision to terminate my contract. And say that we are giving you the decision, the intimation, but the decision to terminate is to follow. So on 5th of May 2022, they only intimate that a termination is going to take place. Then, my lord, finally, my lord, some letters were exchanged regarding final measurement and all those. I don't trouble your lordships with those. And the final termination order is on 30th of August 2022. And this suddenly comes, my lord, without any hearing, without saying what are the grievances against me, etc. Well, I'll take your lordship through the termination notice. But thereafter, my lord, a situation arose which prompted me to file this writ petition. The situation is that the respondents were intending to float a fresh tender for the unfinished work.
At your risk and cost.
Yes. At that juncture, my lord, I have come up before this court, my lord, for a stay of the termination order or the stay of the proposed tender. But on that, my lord, kindly have a look to the order, my lord, which is under challenge, where
As per the supplementary agreement,
yes, my lord,
the work should have been completed on or before
22nd of August 2020.
22nd of August.
Yes. Within 1 year.
22nd May, my lord, 2020.
30th of August was the termination notice.
Yes.
Intimation was on 5th of May.
Yes.
So time to complete the work as per supplementary agreement should have been.
It had expired. Therefore, my lord, I prayed for extension of time on 23rd of February 2022.
It was 22nd August 2020.
20.
Yes, that's what I said.
22nd of August.
22nd of August 2020.
But time extension was not granted.
Was not granted, and I was told that please do not execute any work
For
without.
2 years, they did not grant extension of time.
No.
But in the meantime, in April, they said, please do rectification.
Do the rectification.
Then subsequently, they said, don't carry out unless we extend.
Without it.
No, under the agreement, there should have been an arbitration clause.
Yes, but there is an arbitration clause, my lord, but your lordships know, my lord, this is not an absolute bar. But the exceptions have been called out, my lord, in those judgments where the Supreme Court has said that arbitration is
of course, that is always
alternative remedy. Now, please have a look to, my lord, the order under appeal, which is 10th of April 2023. And in between, I forgotten to tell you, lordship, only one fact.
So the learned judge says that
there's a delay. The learned judge primarily proceeded on the basis that.
And you waited for 6 months to challenge the termination notice.
Yes. Therefore, my lord, I said that why am I coming at this stage?
Para 41.
Para 41 of the writ petition, where I said that there is a proposal.
Now that tender has been floated, retender.
No, according to us, no, subject to correction by my learned friend.
But see, if an request for extension of time was sought for prior to 22nd of August, you could have promptly rejected it.
One correction. The time for extension is not before expiry. It's after expiry. Time to complete was extended till 22nd of August 2020.
As per the supplementary agreement dated 22nd August 19.
Right. But my lord, my extension prayer is on 23rd of February 2022. In the meantime, my lord, there was an general extension because of the COVID period. There's called some Atmanirbhar Bharat, my lord, for a general.
But in between, price variation was allowed.
Yes. On 28th of January and 10th of February 2022.
And what is the percentage of work he has completed?
Well, according to them, we have up to that time 33%.
After extension, it was after 4 years, my lord, almost, my lord.
The tender was given. You have been also complacent.
2017, my lord, the initial tender was given, my lord. Then it was.
So what he will say is 2 years lost in COVID.
Lord, my lord will kindly see the nature of work. The nature of rehabilitation of landslide location. This is the nature of work.
Now, once again, landslide will take place.
Yes.
So, continuous work, no?
He'll
be a perpetual contractor. Throughout 10 years, land will slide, he will repair.
Yes.
Land will slide, he will.
It is not doing so, my lord. It is not doing so, my lord. It has come. It is not that.
Then see, there are two ways of looking at it. One is you can enter into a supplementary agreement, ask him to finish it in 60 days, 80 days, 90 days. Or departmentally you do it by yourself. If you have to float a retender, if there is a risk and cost covenant, then that should be put on hold. Because the writ court says, I will call for affidavit. If the writ court had dismissed it in limine, which we would have done if it had come, probably. We What about the payment for the work done?
That will certainly be made, my lord. Whatever work has been done, my lord, we cannot today say that we'll sit tight and not
The
make
problem
payments.
will arise because unless and until you record in the measurement book, unless you record in the measurement book,
My lord, I did not follow.
no, unless this type of civil contracts, unless you record in the measurement book, there will be a local person from the organization
100.
who will say on a weekly basis, monthly basis, what is the percentage of work done. So you should have closed the M book. If you have closed the M book, saying that till now you have done only this much, I have paid you this much. This is, or if you say you will raise all sorts of things now, the quality of work was not there.
We have done so, my lord. We have exactly calculated his completion of work by the contractor. My lord, we have said, my lord,
But you have not found any defect in that 30% work.
that, my lord, I have not taken instruction. My lord, what is troubling the court, my lord? If
And then if suppose rectification was directed,
Hello.
was it his mistake or nature's fury? We don't know.
No, my lord, today, my lord, will kindly consider this, my lord, in my humble understanding, my lord.
Anything which shall happen in this petition will be against public interest.
Absolutely, that is my, my lord.
And you have contributed to that in not taking
It's not
timely
that, my
action.
lord, I am trying to learn out of my mistakes, my lord. My lord, awarding the contract, my lord, awarding an opportunity for the second time was a mistake, my lord. I ought not to have. My lord, I have given so.
But you have done it, supplementary agreement entered.
Supplementary agreement, my lord, again, my lord, supplementary agreement was done on 22nd August 2019. The time frame within which he was to complete was 513 days, which takes us to 22nd August 2020. My lord, termination is on 30th August 2022.
But in between, you did not allow him to work because you said don't execute unless we extend. Consider your
Even then, my lord, he was to complete by 22nd August 2020.
He's a defaulter.
My lord, if I go to the prayers of the writ petition, if your lordship kindly comes to page 63, those are the interim prayers. He is asking the court for interim orders that the authority do not float any future tender. In my humble understanding, my lord, a tender, to what extent the courts under Article 226 will interfere in a tender matter has been, my lord, spelled off by Supreme Court a number of times. This particular concern that has fallen from the bench, my lord.
Problem is the court did not non-suit him on that ground. It said that we'll hear the matter.
My lord, court was kind enough to not non-suit him.
So
Now,
therefore, we have to see whether the observations made by the learned bench refusing to grant an interim order is just and proper. We cannot say that you cannot argue in this appeal that is writ ought to have been dismissed. It was not dismissed.
When subject to correction by your lordship, my lord, the appeal is a continuation of the entire proceedings. Your lordship can certainly your lordship can go into the merits of the matter in its entirety. Today, your lordship is considering the matter. Your lordship will kindly not consider it on the only prospect of interim order. My lord will kindly consider it on its entirety.
Because the learned judge has specifically said point of maintainability will be left open. Is left open, shall remain open and shall be considered.
So your lordship, everything is before your lordship, my lord.
No, this is an intra-court appeal. Intra-court appeal, testing the correctness of this. Of course, nothing prevents us to withdraw draw the writ petition in here.
Well, we kindly consider the nature of the job, the fault that the appellant has made.
Suppose he files a section 9.
Lord, he is free to do so. There is an arbitration clause, my lord. He's free to do avail his remedies. Lord, if
the work will never take place, because if you invite a fresh tender.
No, my lord, what we have done.
May I suggest one thing as well from the court? Your lordships may fix a date, my lord, and hear out the writ petition. It's
No, it's a circuit bench matter. Circuit is going to start now.
Milord, in that case, give me some protection and till
Instead
the
of
circuit.
that, you can consider, we will say that we will put on hold the revised and the fresh tender. You can consider of inviting him whether another supplementary agreement
yes.
with 100 days.
What has happened, I must disclose this to court. Little instruction, this matter has come to me yesterday only, but little instruction I could gather, Milord. Today we have already, this fund is provided by the central government for this, Milord. So today we have already sent for requesting for approval from the central government, competent authority, to award the rest of the work to by way of inviting another tender. Today, Milord, we are on that stage. Milord,
He can be allowed to go. But balance period, of course, in the fresh tender, he can participate, it's one issue.
absolutely, Milord.
But what about the payments to be made?
Payments will, whatever work he has done, the payments will be made if he is aggrieved. Milord, if he is aggrieved. But NG products a recent judgment of
No,
the
what
Supreme
you will
Court.
do is, the fresh tender, if there is an escalation, obviously there will be escalation of rate. That you will claim from him.
Yes.
That is the problem. Because it is a risk and cost means that is. If they were doing it at, let us say, at 5,000 rupees per square feet, now it will be 7,000 rupees. The differential amount, you load it onto his bill. Square feet is security deposit. Deregister him as a registered contractor. Finish him off. You just get instruction. Because if he has finished 30%, he will say, I have deployed labor, I have stocked this raw material.
Look,
all
that
talkable story they'll make.
in my humble understanding,
Bags of
Milord,
cement I have got.
the Honorable Supreme Court has taken care of it in its decision in NG projects, Milord. Paragraph 23, Milord. The Lordship has certainly seen, Milord. It says, Milord, if tender matters,
They
courts
should
will
not-
be extremely reluctant to interfere. If the parties are aggrieved in any manner,
That exercise will be done by the High Court. I mean, by the Writ Court. That will be done.
Yes.
But when it will be done, probably 2 weeks, 3 weeks hence. Next circuit starts from
Where the circuit bench is from
first of May. The next 2 weeks, this exercise will be done by the court. Until then, whatever you do.
already it is taking some time, Milord. This approval, Milord, is taking some time.
Where the affidavit was supposed to be filed by today in terms of the honorable single judge.
We do not know, must have been filed, might have been filed. We do not know, Milord.
None.
Because liberty has been given to mention the matter.
Yes.
For enlistment. So we will fix a date for the matter. We will fix a date, probably 3rd of May. Until then, you don't finalize the retender. If you issued the notification, let it remain at that. We can't ask you to withdraw it. Don't finalize the retender.
If issued, my instruction is not yet issued. Anyway, if issued,
as I've said, Milord, as I've indicated to the court, Milord,
we leave that issue open.
my Lord will kindly indicate, because this will deter the authorities to approve this rest of the work. What has fallen from your Lordship, Milord, if I have rightly understood, Milord, if your Lordship indicate that the authorities should not finalize the tender, that will have an effect to the approval of the rest of the work, which I have already requested, send requisition
But let
for.
the writ petition be disposed of, Milord, all these questions will evaporate.
Writ petition.
Or appeal, Milord, whichever your Lordship feels, Milord. Or if I may suggest this, Milord, subject to your Lordship's permission, kindly relegate the matter before the circuit bench with a limited protection till 3rd of May. Or 3rd or 4th of 1 or 2 days beyond the return.
Where is that letter dated 13/4/2022?
Yes,
To
it's at page 280. This rectification letter, second paragraph.
But this was some urgent work,
Yes.
urgent repairing of crack. It in the some defect was found in the work already
But,
done.
yes.
But the larger issue is, sir, how
Well, it will kindly,
interfere in a tender matter.
Your Lordship will kindly have a look on the termination itself, which is at page 276.
Why don't you commence arbitration? We'll give you some protection for till you move section 9. That will be because maintainability is difficult, sir, for you to get over.
But I'll address your Lordship on the maintainability point. My learned friend Millard refers to NG projects. But in the latest Supreme Court decision, where Millard, the Bombay High Court, Millard rejected a writ petition on the ground that NG project is a complete ban, sort of a thing. Then when it went up to the Honorable Supreme Court says that the NG project's judgment has been misunderstood by the Honorable High Court, and Supreme Court granted relief, referring to NG project. But I don't have that order right now with me.
Well, kindly come to page 277. Within the time frame that he was to complete the work, he did only 5%. Disturbing, my lord. He was to complete 100% work by 14th September 2018. He did only 5% of it.
But 18 is long over. Thereafter, two variations. Supplementary agreement. Price variation. Rectification work directive.
Where is the supplementary agreement?
Yes, the supplementary effective. It's not annexed, it's at paragraph 13 of the writ petition. We have made an amendment to that effect.
I have a copy of the supplementary agreement. May I hand up a lot? But I have a copy of the supplementary agreement. May I?
Please hand over.
Thank you.
Earlier, you had approached, you had filed an arbitration case. Supplementary agreement records that. First termination.
Yes.
After the first termination, miscellaneous arbitration case 15 of 18 was filed.
Yes.
And dispute was raised.
Yes.
Thereafter, the employer was called for to amicably settle the dispute in New Delhi.
Yes.
Ministry of Road Transport.
Yes.
On 15th of February 2019.
Yes.
And ministry intervened and it advised to revoke the termination after getting approval of the competent authority.
Yes.
Same procedure you resort now. We'll probably protect you for another 3 weeks. By then, that's the best. And in all probabilities, you may succeed because you are a registered contractor with the state public works. That will be ideal.
May I say this, Milord? So far as my section 9 is concerned, Milord, as your lordships know, Milord, section 9.
No, if you earlier,
yes,
they filed an arbitration application
yes,
before the district judge in miscellaneous arbitration, district judge Darjeeling in 15 of 18. In that,
they're possibly
the employer, he
yes,
is your employer,
yes,
he intervened and he said that the contractor was called to amicably settle the dispute. And the appellant was powerful, he got it settled in Delhi. So same,
the same power is to be exercised once.
obviously. That is why they were afraid of touching this person.
For once, my lord will kindly take note of page 278. How many requests we have made for resumption
Correct.
of work?
What we'll do is, we'll stay the retendering process for a period of 3 weeks. He will move the district judge at Darjeeling.
But may I say this, Milord? But to that, Milord, going by section 9, Milord, section 9 is to protect the subject
You are
matter of
stopped by conduct. Come, this intra-court appeal by the writ petitioner is directed against the order dated 10th April 2023, passed by the Jalpaiguri Circuit Bench of this court.
My lord will kindly do it not to finalize within the 3 weeks, and I will be free to take this approval.
In WPA number 674 of 2023. By the said order, the learned single bench declined to grant any interim order in favor of the appellant who was served with a termination notice by the superintending engineer NH Circle Roman 3 Siliguri dated 30/8/2022, terminating the work allotted in favor of the appellant, namely rehabilitation of landslide location with slope protection and drainage improvement at Pagla Jora. The appellant did not challenge the termination notice / order immediately and approached the court about 8 months later by filing a writ petition and writ petition contending that the extension of time sought for by the appellant to complete the work made by the representation dated 23rd February 2022 ought to have been considered, and the time for completion should have been extended. The reason for approaching the court belatedly was sought to be explained by contending that the respondents were about to float fresh tender for completion of the balance work at the risk and cost of the appellant. The respondent raised a preliminary objection with regard to the maintainability of the writ petition, contending that in terms of the contract, there is an arbitration clause and the appellant has to resort to such procedure. The learned single bench, after noting the facts of the case, commencing from the award of the work and as to how an earlier order of termination was passed on 30th of July 2019 and how the same was revoked, etc., held that the appellant has not made out any case for grant of an interim order and directed affidavits to be filed. The court also ordered that the point of maintainability raised by the respondents shall remain open and shall be considered. Thus, the learned writ court, while declining to grant the interim order, has left the issue relating to maintainability of the writ petition to be considered. In our view, the question would be as to whether the termination notice via office memorandum dated 30/8/2022 was just and proper. To examine the correctness of the same, facts are to be gone into. Facts have to be gone into, which cannot be decided by way of affidavits. Mr. Kishore Dattul and a senior advocate appearing on behalf of the appellant is right in his submission that merely because an arbitration clause is in existence, it cannot be an universal bar in all cases to approach this court under Article 226 of the Constitution of India. It may be true that courts have intervened when there is an arbitration clause in an agreement in circumstances warranting such interference. In our view, considering the facts of the case on hand, we are of the opinion that such circumstances do not exist in the instant case for us to exercise jurisdiction under Article 226 of the Constitution to consider the correctness of the order of termination dated 30th of August 2022. One more reason which has prompted us to make such an observation is on account of the conduct of the respondent. As mentioned above, the contract was terminated on 30th of July 2018 on the ground of non-performance or non-performance / lack of adequate performance, as according to the respondent, only 5% of the work had been completed on the said date. The appellant had immediately approached the learned district court at Darjeeling and filed an arbitration application in miscellaneous arbitration case number 15 of 18. In the said application, the respondent department had entered appearance and the appellant was called upon to amicably settle the dispute at New Delhi, with the Ministry of Road Transport and Highway by approaching them on 15th of February 2019, as the funds for completing the project was allotted by the central government. Subsequently, at the intervention of the ministry, by communication dated 25th of February 2019, the respondents were advised to revoke the termination. And after getting approval of the competent authority of the respondent department, the termination was revoked by memo dated 28th of March 2019. These details have been clearly mentioned in the supplementary agreement number 1 dated 22nd August 2019, which was entered into between the appellant and the respondent department after the earlier order of termination was revoked. Therefore, we are of the clear view that the same procedure needs to be resorted by the appellant in the instant case, appellant, as against the termination notice dated 30th August 2022. Therefore, we are of the view that the writ petition cannot be entertained at this juncture. The apprehension of the appellant is that effective steps have been taken by the respondent department to call for fresh tender for completion of the balance work. And if that is done, the tender will obviously be invited at the risk and cost of the appellant, and the appellant would be prejudiced in such circumstances, as it may take a reasonable time to invoke the arbitration clause if the appellant so desires. In the light of the learned advocate appearing for the state submitted that there are no clear instructions as to whether fresh tenders have been floated
Lord,
as on date.
Lord, I have instruction that it has not been
All
floated,
right, then
but we have sought for approval of the remaining.
the learned advocate appearing for the state submitted that till date fresh tenders have not been floated, but the respondents are awaiting approval from the central government.
Regarding the allocation of the rest of the.
The respondents are awaiting approval of the competent authority of central government for allocation of the balance work by calling for fresh tenders. If such be the circumstances, we are of the opinion that leaving it open to the respondents to pursue their request with the competent authority of the central government for approval, the respondent shall not finalize the retender for a limited period, so that the appellant will be able to work out his remedies under the provisions of the Arbitration and Conciliation Act 1996. In the result, the appeal is disposed of by holding that the writ petition is not maintainable, with a direction to the appellant to avail the remedies available under the relevant clause in the agreement and in the agreement read with the provisions of the Arbitration and Conciliation Act 1996. The appellant is directed to avail such remedies within a period of 3 weeks from the date of receipt of the server copy of this order. Till then, the respondent department shall not finalize any retendering process if they so desire to do.
But may it be 4 weeks instead of 3 weeks?
4 weeks.
I will kindly observe that the arbitration court considering their application will consider it on its merit.
Yes. No, they will show this order and get an interim order. we make it clear that in the event the appellant approaches the concerned court by invoking the provisions of the Arbitration Conciliation Act, any prayer sought for before the concerned court or the arbitrator shall be decided on merits and in accordance with the law, uninfluenced by any of the observations made in this order.
Very grateful, my lord.
I'm grateful.
The writ petition and the appeal disposal. Next.
Appellate side daily list, item number 9.
Somebody wanted adjournment.
Yesterday, we were the writ petitioner. We succeeded
But
in the writ petition.
it's your appeal.
Lordship, I beg to appeal.
What is this?
My lord, emergency credit line guarantee scheme. My lord, we say that we are eligible under the scheme. It's 100% guaranteed scheme. So one of the challenges in the writ petition was the steps taken after classification of my account as a non-performing asset that went before the DRT. So the learned judge disposed of the writ petition only with respect to the emergency credit line guarantee scheme by factually coming to a conclusion that I was eligible based on their document and said that I am entitled to the benefits under the scheme, which is, my lord, your lordship is aware 1.0.
Then you want it tomorrow. When do you want it?
It's their appeal, my lord.
No.
Oh, yes.
Adjournment was sought for on your.
Yes. Oh, so any day convenient to your lordship.
When
Lordship,
or Monday, my lord, your lordship takes up residuary matters.
The only problem, Lordship, is that
Wednesday, Wednesday.
If my learned senior would kindly undertake that no contempt or any such proceeding will be.
Even if he files, it won't be listed. Don't worry. For 1 month, it won't be listed.
Even then, Lordship, some assurance of.
No, but the thing is that, my lord, what contempt? They have been directed. I say I am eligible.
If they don't obey that order, then
Lordship, representation has already been given
naturally
by my learned friend to.
All right. At the request of the learned advocate appearing for.
So, but then
the
take it up
respondent writ petitioner, not tomorrow, Wednesday.
Wednesday.
Till then, the respondent writ petitioner shall not initiate any coercive action for implementation of the impugned order. Till Wednesday.
Lordship, the affidavit of service may be taken on record.
List on Wednesday, same position.
As per foundation, we should have proceeded.
26.
Next.
26.
Item number 10,
10 to 14.
Ah.
Mr. Bikazonan Bhattacharya, I am led by Mr. Bikazonan Bhattacharya. He was here.
He was here.
Yes, but just now he left the court number 19. So I am praying, let it be taken up these 5 matters on next Thursday. It has been, this order was, my lord, similar order was passed by your lordship in.
Similar order ex parte. None appears on behalf of the state. I do not know, my lord, what submission was made.
That we shall pray
And, my
before
lord,
your
in
lordship.
any event,
Whether
this matter, the rest of the matters,
If
my
your
lord,
lordship
joint
takes-
prayers on behalf of state. My
Let
lord,
it be
kindly
taken
hear
up in
and then
presence of Mr. Praranjan Bikazonan Bhattacharya. Let
That
it
is
be
a
taken.
step.
Where is the impugned order?
My lord, impugned order is page 67. My lord, similar order was intervened by your lordship.
Ex
Wait,
parte.
one second.
None appears.
You are saying similar order, they are saying not.
My lord, that whether the subdivision officer, my lord, whether this,
Declaration and by submitting my lord the false documents.
my lord,
That is the
whether
my lord
the
the facts of the
subdivision officer has any authority to cancel the scheduled tribe certificate when the state vigilance commission is the authority. That
If
is
it is
your
if it's a scheduled tribe certificate,
yes.
genuinity can be gone into by the vigilance.
My lord, this is the order passed by your lordship in similar
My lord,
cases.
please, my lord,
Wait,
please.
You get that order.
Similar cases, we shall
Get it.
we shall pay for
As if it's a
similar
time
order.
bomb.
My lord, only date are changed.
Wait. Let us
Only
down
dates
to
are
the same.
changed.
Yes.
My lord, so far, this order passed by your lordship, my lord. Rightly, my lord, I cannot say that this order should not have been passed, but my lord, this order was passed, my lord, that in absence of this learned state advocate. Now, my lord, I do not know, my lord, what was the facts and circumstances therein. But so for the rest of the matter,
He'll ignore that order.
yeah, for that time.
That is only interim order.
No, my lord, do not ignore, but let my learned do not rely upon it solely. What our joint prayer.
No, he is relying on Supreme Court judgment.
Yes, yes. Now, my lord, the question is, আপনি একটু বসুন, please. আপনি
দেখো,
There is another division in judgment of this Hon'ble. The Supreme Court judgment was considered. And it was said that it has a persuasive value as because the West Bengal SC/ST Identification Act 1920 was an act legal judgment. So, my lord, that division when judgment, we have placed that division. I don't know whether you know.
So there is an
Price of
amendment.
this judgment.
No.
Passing.
Amendment.
So, lordship,
Amendment.
that particular judgment, it is another honorable division bench of our High Court has been instituted that so far as cancellation of this certificate is concerned, under section 9 of this
কার কাছে গেল?
section 9 subsection 1 certifies issuing authority as the power to cancel. But so far as the section 9 subsection 2 part is concerned, it can be referred to the state scrutiny committee, which my learned pursuant to Madhuri Parliament. It can be the forum that scrutiny committee can be regarded as a supervisory jurisdiction. Since there is no appellate forum, this was said here by the Honorable Division. 20. Now in the year 2020, below the act has been amended in the month of November 2020.
Prior it was in the rule, then my lord, the act amended, inserted in the act.
9A has been drafted, making an appeal provision. So, my lord, this judgment, I believe, was not placed before.
No, it is only an interim order.
Yes, I find the state was not represented on 10th, 13th April.
And another thing is, lordship, so far this branch of matters are concerned, here what happened, here the fact totally different from the ballot facts in the Supreme Court. Before the Supreme Court, it was the fact that two ladies, they separately, my lord, filed application before the appropriate authority for, my lord, issuance of caste certificate. Now, particular caste certificate, when they did apply, my lord, that was refused. Later, what happened, my lord, they preferred an appeal against that before the commission. Now, the commission said that particular caste, there, so far that particular, my lord, a community, for the community, the caste certificate can be issued. And he belongs to that community. So the question arose whether who applied belongs to that community or not. Because the caste certificate already can be issued in respect of that community. Here what happened, my lord, kindly consider the facts why different, but without going through the, my lord, the papers. Here what happened, my lord, the read petitioners who were, my lord, they, because a bunch of read petition, my lord, now one after another, my lord, they applied for a scheduled tribe or scheduled caste certificate in 2016. Now, they obtained that from the appropriate authority, their application made and they obtained that. Later on, what appeared, my lord, in a selection process, because they used that certificate after 2016 obtaining that.
Genuineness was sought to be verified.
In the selection process, my lord, when they participated therein, my lord, repetition filed by others. Now, I'm সেটাই বলতে চাইছিলাম
education matter. Came across 55 candidates who are in job of the government as assistant teacher. They are on enjoying the benefit of reservation. Those AC certificates of doubtful offense. And they are directed different districts of the authority initiate activities.
Now what happened? Pursuant to the direction of this Hon'ble Court, now the authority took up the matter under section 9 within bracket 1 and with the corresponding rule 3 of the rules and 3.1 and other. Now they were asked.
So this inquiry was based on a direction issued.
Yes. Now thereafter what happened? My lord, a longish order passed by the authority concerned. In the said order, which was impugned before the read court, what happened? In the said order of the authority concerned, which was impugned before the read court, it appears that they were asked to produce certain, my lord, the documents on the basis of which in 2016, the caste certificate was issued to them. It was not with regard to that, whether that community belonged to the caste or not. It was their individuality, whether they belong to that caste or not. Number one, it appears that they were asked to produce certain documents on the basis of which in 2016, my lord, their caste certificate was issued. And specifically, two documents, because so far this matter is concerned, item number 10 it appears from the record that the, my lord, the read petitioner, he was asked to produce at least 2 or 3 documents which belongs to that you relied upon your father's voter card and other card and your uncle's voter card and other card. You please produce the same again and nothing more. Produce the same again. Then he said that original does not belong to me. Then eventually and finally produce the same. Then the inspection was done by the inquiry committee. Time to time it proceeded on. The inquiry committee upon inspection came to a finding that those were the fake documents. Now, my lord knows that, my lord, fraud undone everything. It was a fraud and a lot, it is mentioned therein. Then again, he was asked several times, he made his representation personally. It is not a case that Article 14 was hit. Then he, my lord, failed to produce any other document except those fake documents. And the findings of the inquiry committee, on the basis of which the order passed by the authority under section 9 within bracket 1 of the act, that since the certificate issued on the basis of fake documents, so you are not entitled to enjoy the same. And if you are not entitled to enjoy the same, the fruits based on fake documents, so you have to, we are cancelling it and you have to surrender the same. Now, against that, my lord, the read petition filed challenging the same. The read court said that these are all matter of evidence. So better it is remitted to the before the appellate forum, because section now the, my lord, the amended section is there and the rule already there, rule again is there, that before the district magistrate. So the question is very simple, that after an inquiry and
so the appellate authority has got power to grant interim order?
No, appellate authority, may I tell lordship?
Because
This is a very vital question.
Liberty to seek interim protection under Rule 5 of the 1995 rules.
Now, my lord, the Rule 5. Rule 5.
Our.
No, my lord,
case
yes,
is that-
admit.
that-
Actually, when we passed this order, nobody, you have not brought.
Expertly order নিয়েছেন, admit বলতে দিন।
Without jurisdiction, because
Yes.
Supreme Court always says
Supreme Court,
that
that
State
matter
Vigilance Commission,
did
State
not
Vigilance
consider the
Commission
statutory purpose.
Wait, sir.
State Vigilance Commission is the authority, how to.
Correct, sir. The problem is, this argument was not, this was not placed before us when we passed it. To our
But your
knowledge,
lordship, my lord, that is the law. That
no,
is
no,
just-
correct. Nobody has challenged the law, enact the, what is it,
Our
1994 Act.
Our interpretation follows each and every line which your lordship passed the order, that the subdivision officer has no authority.
This is not a judgment, it's only an
Let
interim
him
order.
come with evidence.
But
you
this
come
is
to
the,
your lordship,
this
but
is the
immediately
rule,
get-
this is my lord, the rule 7G. Now, my lord, only submission before your lordship is that it fell from your lordship on other occasion also, that whether the statutory appellate authority has any power, my lord, to issue an interim order or not.
Appeal against. An appeal against cancellation bonus also shall lie to the district magistrate service. Where certificate is cancelled. Here the cancellation is by subdivisional officer.
Yes,
Yes.
yes.
She says, Rule 5, there is a power.
Who is the issuing authority also?
This is the amendment.
Yes.
But under the rules,
My lord.
7G,
My lord.
there is no power to grant interim order.
My lord, the statute, my lord, subsequently, my lord, the amended, if your lordship kindly have the very recent amendment,
Oh,
it was not, my lord, the appeal provision. Further, my lord, after amendment inserted therein.
There is no such power.
The copy has been-
No such power. If only appellate authorities, time was extended from 20.
9A.
Now, you have lost your job. They have
No,
dismissed you.
No, because we are under process.
This is see, there are two independent proceedings. One is the genuineness and validity of the certificate has to be considered by the authority in terms of the amended act. If suppose there is a threat to your employment, you come by way of writ petition.
No, that is our reach. That we shall lose our job.
Unless a show cause is issued, pending verification,
My lord, kindly see.
appeal is the continuation.
5 says that it will be informed to the authority where I am getting the benefits. Rule 5.
Yes, Rule 5 it says so.
Says so. That's, and you, our case is that the proper authority should adjudicate it.
But this is the
Because
proper
kindly-
authority as per
kindly-
the act.
kindly
The
after-
act has not yet been
After
challenged.
affidavits, kindly adjudicate it once for all.
Act has not yet been
No, you have
challenged.
not challenged the provisions of
No,
the
no,
act.
no, not yet. No.
Wait, sir.
Sorry.
You have not challenged the provisions of the act. When we passed the interim order, we were not aware of the statutory amendment or such a, I was not aware that there is an identification rules framed by the state of West Bengal. This clearly provides for an appeal, as rightly said, facts need to be gone into. He says it's a fake document. You can always establish it's not a fake document. It's not a fake document. That exercise you do. In the event a show cause is issued, saying that you obtain the job.
Kindly in the meantime, then in the event where I stay not to take any further steps pursuant to the order.
We will give you liberty. In the event something happens, that liberty can be granted. In all these.
Something may happen, my lord, any day, my lord, you kindly protect me up to 2 weeks of the disposal of the appeal. No
Let us-
effect should be given.
These appeals, intra-court appeals, common order,
And these
are
are
directed
statutory
against the orders dated 21/3/2023 Sir, we have to verify whether it's same date. In 21/3/2023. In the various writ petitions filed by the appellant. Though the orders are individual orders, the issue involved in all the appeals / writ petitions are identical. The writ petition, the appellants were aggrieved by orders passed by the subdivisional officer cancelling the cash certificate issued to the appellant. The learned single bench had disposed of the writ petition by directing the appellant to prefer an appeal before the appellate authority concerned, and also seek for appellate authority concerned. Agreed by the same, the appellant are before the appellants of the agreed by the same, the writ petitioners have preferred the present appeals. We have heard Mr. Bikas Ranjan Bhattacharjee, etc., etc. The first argument of the learned advocate for the appellant is by placing reliance on an interim order passed by this court on 13th April 2023, by which the court took into consideration the decision of the Honorable Supreme Court and observed that the competent authority to inquire into the genuineness of a caste certificate issued to genuineness of a scheduled tribe caste certificate is the State Vigilance Commission, and therefore there was a order of stay granted. After elaborately hearing the learned advocates appearing for the respondents, we find that when the interim order was granted in MAT 574 of 2023, the relevant statutory provisions were not placed before this court for
Even
consideration.
State Vigilance Commission has been amended. He has brought to the act. State Vigilance Commission.
In any event, the same being an interim order, it would not bind us while considering these appeals on merits. In terms of the West Bengal SC/ST, West Bengal Scheduled Castes and Scheduled Tribes within bracket Identification Rules 1955, in Rule 7 capital G, an appeal has been provided against any cancellation, impounding or revocation of certificate by the certifying authority. In terms of Rule 7 capital G within bracket 1 within bracket small a, when an order of cancellation has been passed by the subdivisional officer, appeal lies to the district magistrate or the additional district magistrate. Taking note of the said provision, the learned single bench had directed the appellants to avail the appeal remedy. That apart, the provisions of the West Bengal Scheduled Castes and Scheduled Tribes within bracket Identification Act 1994 was amended by Amendment Act 2022. And after section 9 in the 1994 Act, section 9 capital A was inserted, which is as follows. Thus, in terms of the above statutory provision, an appeal lies to the district magistrate. The appellants have not questioned the validity of the amended provisions of the Act, nor the rules. That apart, the ground on which the certificate was cancelled is alleging fraud. If that be the case, then the factual position needs to be adjudicated, which cannot be done in a writ petition. Therefore, the learned single bench was right in relegating the appellants to file an appeal before the appropriate appellate authority, and therefore the order impugned does not call for any interference. The learned advocate appearing for the appellant submitted that consequent upon the cancellation, The learned advocate for the appellant submitted that the petitioners apprehend that they will lose their employment
Because they are all teachers.
and they are working as teachers. If it is found it's a false certificate,
Certainly.
they have to go behind bars.
Yes, yes.
They are working as teachers. And in the light of Rule 5 of the said rules, in any event, the certificate having been cancelled, the question of granting an interim order and restoring status quo ante would not arise. However, in the event there is any threat to employment of the appellants, it is an independent cause of action and the appellant would be free to avail the remedies available to them and under law.
Get
The above observation appeals.
and all the five. appeals.
5 appeals. Thank you, sir.
Get.
Your lordships, if I may. Lordships, if I may mention item number 19.
Lordship, give me
Lordships.
leave to mention, my lord, lordship, item number 75, my lord, lordship granted me, my lord, asked me to give notice to my learned friend, my lord, he's appearing.
ওইটা নেব ওইটা নেব না থাকবে ওইটা থাকবে
But tomorrow it won't come. 75.
My lord, the contempt application is, my lord, fixed for hearing tomorrow, my lord.
Don't take action. But it's come on Wednesday. Please take action. We request you to take it. Wednesday it will come.
Your lordships, if I may mention item number 19, a fixed date may be given, your lordships, on that matter.
Today
Item
is the
19.
date fixed. You said resolution 330 what? Wait.